Colleagues, thanks very much. I think we're going to start with the meeting. I perhaps must DM apologize to you and the team for having delayed you, and also to the suspended CEO for having delayed all of you guys for the housekeeping matters that we needed to deal with. It is not out of our own making, it is out of the developments in your own entity that we find ourselves having to go up and down. I think that must be understood. DM, we invited you, like I said, as a sequel to the discussion that we would have had. Yeah. No, but it's you who's disturbing us. Why do you want to transfer it to Mabena? Because you're having a red caucus there. No.
I don't know what's wrong with Honorable Blosser today. It's like there's a bit of excitement.
Yeah, and I'm going to suggest, if you continue that way, I'm going to suggest that Blosser sit where you are seated and you sit where Blosser is seated.
I think very progressive, Chair.
Yeah, but nonetheless, colleagues, at least we are one. We clarified each other. There's certain things that we needed to clarify each other on. We are one. We are proper. We are going to allow you, DM, to take us through in terms of what we would have asked. We are fully aware that there are certain matters, like I indicated, which are in court, which we may not be able to express them properly. Yes, Honorable Mabena.
Thank you very much, Chairperson. In what you are saying now, that the committee has agreed we are one, we just want to register the dissent of the TA, that we don't agree with the issue that is happening now, in terms of having an acting CEO of the entity with a suspended CEO, with the board that suspended that CEO. So we just want to register that the TA is not in support of
no, thanks very much.
But will engage with the board and the acting CEO.
No, thanks very much. I think that is recorded, colleagues. There is that particular dissent. If there is anyone who wants to make that dissent, let's quickly deal with it now, so that we do not shock each other in the process.
Chair, I don't understand why you are allowing it, because the board had taken a resolution. Now to speak to the cameras and tell your bosses that you are disagreeing, it's a collective decision we've done.
No, it's fine.
Those issues, you don't need to report. Can't tell cameras those things. It's done. Leave it.
Honorable Bloss, I don't know what these cameras doing to you and Honorable Mabena today. I really don't understand. Whatever commitments, colleagues, you would have made, wherever you have made them, please, can we run a meeting now? Honorable DM, but before that, I'm going to request in our part, Valerie, that you read the apologies that we have, and obviously DM will also take us through the apologies. From there, DM, I don't know, you lay a background, and from there, whoever has to present in your part will present. Thanks very much.
Good evening, members and the Road Accident Fund. Apologies were received from the Minister and from the from Parliament, from Ms. Makau and Dr. Hunsinger, from the Road Accident Fund Board, Advocate Njeza and Mr. Sello.
Is there any other member who wants to raise any apology that we do not know? If it's not there, let's proceed. DM, over to you.
Thank you very much, Chairperson, Honourable Chair, the honourable members of the Portfolio Committee. The Road Accident Fund and ourselves are here in response to an invitation by the committee following the meeting we held virtually last week. Chair, the invitation had indicated that the meeting would be going on until 8:30. I am scheduled to attend the disaster management meeting this evening, starting at 8:30 because of what is going on in the country. So in the event that I do step out, it would be to ensure that the team we have now asked to stand in for us because of the delay here would arise out of that. Secondly, Chairperson, is to indicate to you that the Road Accident Fund has put a disclaimer in its presentation about how matters need to be handled, in light of the fact that yesterday I was advised that the suspended CEO had served papers on the Road Accident Fund, and that the Road Accident Fund had to file its affidavits today, for the matter is set to sit on the 17th of June 2025. After consultation and discussions, we still felt it prudent to honor the invitation by the committee in order for it to exercise its parliamentary obligations. It is therefore, Chair, my belief that you will assert, for the purposes of engagement, the Powers, Privileges and Immunities Act, for the purposes of this engagement, that this portfolio committee meeting will perform its functions, understanding that the matter is now in court for the purposes of a competent court to make a determination on the material facts of this matter. And so I think, Chair, it would have been helpful at the start of this meeting, and because there's a Zulu saying, I will not complete, Odindlebe is something. And we have heard.
What is that saying?
I can't complete it.
Oh.
So will. I think it would be helpful for you, Chair, to guide on how you want to handle this meeting, because you are saddled with a situation wherein the board of the entity has taken a decision to suspend its CEO and appoint an acting CEO, and post that the matter is now in court. So we would want the committee to give us parameters on the rules of engagement in terms of this portfolio committee meeting. Secondly, Chair, it's to indicate to yourselves, or thirdly, that I had a full day meeting with the board and executives of the Road Accident Fund yesterday, as committed in the correspondence I sent to the board at the advent of this matter, and as also communicated to the portfolio committee when we met on the virtual platform last week. The acting director general and I, who's here, are compiling a report in order for us to explore the next phase of this engagement, with a view to ensure that the entity is stable and that the entity is able to fulfill its responsibilities. We will subject ourselves, Chair, to this process, as is the constitutional injunction of the committee to perform its functions. The board, which is present here, will take you through the sequence of events of the matters currently at hand. My final point, Chair, is to indicate that the matter we are dealing with, amongst others, because I think I need to give that qualification, is currently a subject of two committees in this Parliament: the Committee on Public Accounts and the Portfolio Committee on Transport. It remains my fervent outlook and humble request, Chair, that Parliament finds each other and itself for the purposes of coherence and reporting and accountability. We are saddled with the situation that SCOPA has got its own timelines, and I'm pretty certain this committee will also have its own timelines. There is responses which were due to SCOPA, and I've requested an extension because of the latest developments, and that deadline has now been extended to the 20th of June, as for us to be able to submit the necessary information. I conclude, Chair, by saying in the final analysis, the situation at RAF is not good. and is cause for concern on a number of material fronts, including but not limited to the situation around the suspension of the CEO. I do not think that it is a light matter, and I do not think that it is a matter to be handled willy-nilly because of the material consequences it has for the organization. It does require us to tread with a particular caution, is not to exacerbate the situation further in the wrong direction, because this suspension, amongst others, comes at a time where there are a number of difficulties which are there. Lastly, is to indicate that, as the board will share, the genesis of this matter being here today, from the understanding of the ministry, is as follows. One, the Standing Committee on Public Accounts was briefed by the SIU on the basis of a preliminary report of an investigation into matters within the ecosystem of the SIU. SCOPA then requested, after that briefing, that the Road Accident Fund come to Parliament to engage on the basis of that meeting. Amongst others, it brought to bear a toing and froing of communication on the basis of what I consider to have been a wrong decision on the part of the board to say that they would not come to Parliament. I wrote to the board. They engaged as a board with the committee and with the SIU to clarify their issues. It remained the position of the ministry that whatever issues that the Road Accident Fund had were to be ventilated in that committee meeting as opposed to correspondence. It is now common cause, as established last week in the meeting that you had, that sequence and series of events led to letters by the now suspended CEO to the Standing Committee on Public Accounts, and an indication that he would not be attending. Subsequently, of course, that meeting took place in Parliament, wherein issues were raised when whatever issues may have been of RAF were explained in correspondence, which the board will actually speak to. The special leave which was granted or given to the CEO was rescinded by the board for reasons that they will explain, and then a precautionary suspension was effected. So as far as we are concerned, that is where we are with the matter. I am not privy to the court papers, and I'm not privy to the responses of the Road Accident Fund to that court action. Suffice it to say that I have requested the SIU to brief myself on the nature and circumstance and the extent to which the investigation has gone on, and where it is, or its current status is at this point in time. This information harvesting process I'm engaged in, Chair, is ultimately for the purposes of ensuring that the right and correct decisions about the future and strategic direction of RAF are taken. And I say that on the basis that this is not a light and easy matter. So I thought I should give the background in terms of what we know and in terms of what we understand as the board exercised its own responsibilities as per the prescripts of the law is concerned. I do want to conclude by expressing a concern, Chairperson, to say, to indicate that I do not think it is prudent for us to play speculation in the public domain, as this matter has done. I would want us to engage on the basis of facts. And I intend, Chairperson, on writing to the Speaker of the National Assembly on utterances of members of the House outside Parliament on this matter, which have sought, as far as I'm concerned, to dangerously seek to advance a narrative which is outside the facts and without the protection of the powers and privileges extended to members of Parliament. Because it's the rules of this House which must guide our engagement. So I've been concerned by that, and I intend on raising it with the Speaker and yourself, and I think the Chairperson of SCOPA is another committee that is dealing with this matter. Chair, the board has prepared a presentation which I believe has been circulated to yourselves, and would now request that I hand over to the Chairperson of the board to actually lead the presentation with her team. The acting CEO is here, and executives and board members are present. Suffice the apologies that have been read. If there are any others, we will engage correctly with those. And lastly, Chair, to indicate that I will not be drawn into a public spat on a serious and sensitive matter of this nature, which has got a material consequence for the organization and the exercise and discharge of its responsibilities. Thank you very much. Chair, over to you.
No, maybe before the chair comes in, one is to respond to one that you said you'll be stepping out. I think we'll allow you to do that as long as the acting DG is here, and together with the board, then they'll hold the TAF in your absence. I'm not sure whether by the time you finish will not be done, but I think I strongly believe will be done. Or in whatever process you want to do, if it's going in and out, you are allowed in that. Secondly, that in terms of how the meeting must run, merits that you think will compromise your matter that you are dealing with somewhere else, you can indicate that on this matter we feel that we can't, even if there's a question, if you feel that this question is problematic, you may indicate that. Same goes to Mr. Lutswalo. If members ask you questions that you feel that this one is going to compromise what I'm dealing with, you are free to indicate that. I don't think overall the other advice that you actually raise is that we'll be engaging with the Standing Committee on Public Accounts. I did get a brief in terms of various reports that I would have received from the chair, in his capacity as the chair, from chair to chair. I'm going through those particular reports, but I think at a particular time we'll have a joint engagement with them so that we move from the same wavelength. But it is important for this portfolio that it has all the information so that we don't engage with the other committee with a standing committee, for instance. When you are an oversight committee, the standing committee has more information than yourself. It means you are actually sleeping on duty. So that is why this type of engagement, as we prepare for that type of a shared engagement, is important for us. So we'll deal with that. I seriously note your concerns relating to members who speak and things that are perhaps outside the powers and privileges, or things that are outside the scope of our engagement. I'll wait for that brief as you write to the speaker, and also if I will have you'll have the generosity of also sharing with the chair of the portfolio. We'll await that. So we'll proceed in that manner so that we move as speedily as possible. You take us through the report. Members have went through the report to a great extent, so you can just be summative and go through it. From there, I'll just allow members to ask you questions and engage with you on areas that, like I indicated, that you feel you'll be compromised. You'll indicate, and we'll take it from there. From there, they'll also ask certain questions that they may want to ask to Mr. Letswalo, and then we'll take it from there, and then we'll close the meeting. I hope it works
No,
for you.
Chair, that is very much in order. Thus, my step out will be to ensure that our team has joined the meeting of the disaster management. As you know, we are saddled with the tragedy of having already lost 49 lives in the Eastern Cape, and the situation continues to be adverse, and road infrastructure, of course, is key and material in that regard. So thank you very much, Chair. I think the chairperson of the board...
On that note, may we then observe a moment of silence in honor of those who passed away through this tragedy. May their soul rest in peace. Thanks very much. Sure.
Much, Chair. I think the chairperson of the board has heeded you or heard your guidance, and I will now hand over to the board. Thank you, Chair.
If you could quickly introduce Usu, because
Chair, I assume the within Yazana because you've also visited RAF. Chair, my name.
yeah, unless honourable members are comfortable, or as members speak, they'll introduce themselves so that we save time. Yeah.
Yeah.
No, Chair, but let's quickly introduce. I think it's proper. Yeah, don't take.
All right. Chair, thank you very much. My name is Mkuda Watlangwa, the Deputy Minister of Transport.
Good evening, Honourable Chair and members. My name is Lorraine Francois. I'm the Chair of the Board.
Good evening, Chair and Honourable Members of Parliament. My name is Dr. Nomande Mabuya Mulweli. I'm the Deputy Chair of the Board. Thank you.
Evening, Chair and Honourable Members. Dr. Pamela Pongega-Matebula, Board Member.
Good evening, Honourable Chair of Portfolio Committee and members of Portfolio Committee. My name is Moses Nyama. I'm the Chair of the Audit Committee. Thank you.
Good evening, Chairperson of the committee and honourable members. Spiwe Blose, the board member.
Any relationship? It matters.
Good evening, Chairperson and the honourable committee members. My name is Dr. Pulile Dladla, and I'm the Chairperson of the OPS-IT Committee. Thank you.
Doctor, you may want to unpack what OPS-IT is.
OPS-IT is Operations and Information Technology Committee.
Of the board.
Of the board of RAF.
You had confused my members. Thanks for that intervention, dear, because I see members are licking their lips.
Good evening, Chair and honourable members. My name is Kwenako Mapi, and I'm a member of the board.
Good evening, Honourable Chair, honourable members. My name is Bongiwe Khumalo, and I am a board member at the RAF.
Good evening, Chair and honourable members. I am Radikwena Pora, the Chief Internal Audit Officer at RAF.
Good evening, Chair and honourable members. My name is Bernice Potgieter. I'm the CFO of RAF.
Good evening, Chair and board members and all committee members. My name is Advocate Piladi Moahi. I'm the Acting Head of Legal at the Road Accident Fund.
Good evening, Chair, honourable members. My name is Mampe Khumalo, and I'm not the head of legal. I don't have an LLB, but I'm the Chief Governance Officer of the Road Accident Fund. Thank you.
Good evening, Chair and honourable members. My name is Patuchedzo Kwareni. I'm the Acting CEO.
Good evening, Chair and honourable members. My name is Tulan Chawalala. I'm a board member.
Evening, honourable Chair, honourable members. My name is Mukiti Penani. I'm the board secretariat. Thank you, Chair.
No, Chairperson, I think we are very much in your hands. Mdula Stul, over to you.
Thank you very much, Honourable Chair of PCOTS and members again, our Honourable Deputy Minister of Transport, our Honourable DG, as well as Honourable members of SCOPA that are in attendance, as well as all the other members that are in the room and the members of public. Let me just observe protocols for anybody else that I did not include, and the members of the board and the RAF executives. Chair, I think the DM has opened up appropriately in terms of why we're here, and the fact that the RAF is always committed to account in terms of how we run the organization called the Road Accident Fund. And we respect the powers of the two committees of Parliament that we account to, which is the PCOT and SCOPA. We understand that Rule 227 of the National Assembly actually empowers these committees to exercise oversight over the work that we're doing within the entity. But I'd like to start with the fact that relating to the matter of the suspended CEO, I've been guided in terms of common law principle that proper administration of justice should not be prejudiced, especially when it comes to a matter that is already in court. And I'm saying this all further with the fact that we have the suspended CEO of the RAF in attendance to this meeting. So I just believe that if, in fact, I've been told not to answer any questions or present any facts relating to this matter because it will actually compromise the RAF case as well as the board case that is currently in court. So what I'll do, Chair, because in terms of making sure that we give you the sequence of events, and the Deputy Minister has done that already. What I'll do, I will just emphasize the key decisions that the board took around this matter. Just for the record, I'm also cognizant of the fact that on the 3rd of June 2025, the RAF board actually attended a PCOT invite, and the deputy chairperson that was representing me on that day, I'm aware that she took the committee through the sequence of events up until that particular day, which was the 3rd of June. And so I will basically confirm the key decisions and the dates, and then up to where we are today. And then what we'll do, I will allow the acting CEO, Mr. Lukwarani, to take us through all the other matters. But in terms of all the matters relating to the current case that is in court, I will not go beyond the sequence of events and the key dates, because then I'll be failing in my fiduciary duties in protecting the best interest of the RAF in this regard. However, I would like to assure the committee that once the matter is out of court, I mean, the DM is giving you the dates that the matter is set to be heard on the 17th of June. I think it's about next week, but we commit that the RAF board will come back and account further once the matter is out of court. And I'm emphasizing the fact that the deputy chair gave the sequence of events at a time when the matter was still an internal matter within the organization. So there were no restrictions at that point in time. But now today we're sitting, with the different circumstances that now that the matter is in court. But let me not waste too much of your time. Let me just confirm the key dates and that basically started this whole matter up to where we are today. The first decision of the board in this regard was taken on the 27th of May 2025. And we all, I think it's on record, that the sequence of events and the issues that took place started with the SIU matter that we were supposed to go and present on the 28th of May before the SCOPA committee. And because of some issues of defiance, the board took a resolution after considering the matter before them to ensure that they are not prejudiced in terms of them coming to actually account before a very critical parliamentary committee on the matters that are affecting the RAF, because obviously we are its board. So that decision was taken in consideration of those matters that were before them at the time. And we believe that that was the appropriate decision at the time because it was not a preconceived decision. We were dealing with a crisis that was before the board, and the board had to act to deal with that crisis and also make sure that it discharges its duty to come and account before a parliamentary committee, which is very critical in this country. So the first decision was to place the CEO on special leave. That was the 27th of May. That was following a board decision. And then on the 2nd of June, after taking legal advice, I think it's very important that the board came back and reflected and looked at the magnitude of the conduct at the time, the misconduct, if in fact, to be precise. And we took legal advice and we, excuse me, then the board took another resolution. Two resolutions actually, Chair. The first resolution was to withdraw the special leave and then replace it with a full suspension. That was on the 2nd of June, 2025. And then I think 3 days later, on the 6th of June, the board received a notice of motion of basically the CEO raising matters to dispute the suspension in courts. That was on the 6th of June. And the board held a special meeting and considered that motion and took another resolution to defend the matter. So currently the matter is in court. Today we were busy. In fact, in terms of that decision, the chair of the board is actually charged with the responsibility to depose of the answering affidavit in terms of dealing with the defense of this case. And that's why our legal team made it very clear that and I can't answer any questions beyond this or get into too much detail on the matter because it will compromise the case of the RAF as well as the board. So, Chair, let me end up here and I will allow Mr. Lukwareni to continue with the rest of the presentation. It has been shared with the committee. Thank you.
Thanks, Chair, and good evening again. Mukiti, if you can just go to, we have been asked to answer specific questions over and above the issues I think that the Chair raised, and I will just run through those quite quickly, Chair, because the first issue was around vacancies in the fund and some of the reasons why they have not been filled. So just at a high level, the vacancy rate at the RAF is around 17%. That is across the organization. We have been implementing a new organizational structure that was approved on the 31st of March 2022. And then obviously the filling of positions was also impacted by the by a halt to the Section 189 process that was taking place following engagements with organized labor. But the next slide will just Mukiti, will just show you that at the high level, in terms of the ex-core positions, we have 3 vacancies in the main, and the vacancies, of course, that had where we have had serious difficulties in filling the positions include that of the chief claims officer. We have gone to the market a couple of times in this position, but we now have to go back to the market, but we have now appointed someone to act in that position. The chief corporate support officer also suffered a similar fate in terms of multiple attempts in the market. But I think we are more hopeful with this one, because I think it's also at an advanced stage, because I think the assessments of candidates have already been done, and we are ready to interview. The chief investment officer position had also been put on hold. The main reason I think the board took at the time was to first process the investment policy to guide the process going forward. I think those are the main positions. The rest of the positions in the EXCO are filled. In terms of the second question, that mainly related to the leases of the offices of the RAF for the past 10 years. I think that was so I'll just talk to the overall cost without necessarily going into the details of the offices over the past 10 years. I think if you go to the next slide, Mukiti, that's the one that has the totals. Yeah, that's the 854 million over the past 10 years, of course, across all the offices, and these amounts also include included in the also include water and electricity, operational cost, security, and on all aspects. But that's over 10 years. You can see all the buildings there, the specific offices. I think we try to be as transparent as possible. Next. I think we were also asked to put addendums of when these decisions were taken to the board and when the board approved extensions and the original contract. We've put all those details there. Next, Mukiti. We were also asked to update on the status of the panel of legal service providers used by RAF and the reasons for the reported increase in summary judgments against the RAF. Just at a high level, we have provided the committee with high level with the attorney allocation criteria in terms of how the panel is structured, that all these attorney firms are structured according to specific categories, whether it be public law, personal injury, labor and employment law, and obviously just to also emphasize that as part of the appointment process, the 2 firms that were mainly raised, I think, are arising from the engagement with SCOPA, also find themselves having been appointed to participate in, I think it's 3 of these categories. There were other issues that we wanted to also bring to the attention of the committee around how the panel operates. There are so there are 12 firms, for example, that have that can be briefed because of conflict of interest, and in this regard, conflict of interest mainly relates to them still doing plaintiff work, RAF plaintiff work, which makes it difficult for them to then represent RAF on those similar matters. Obviously, we have a process where there is disclosure around conflict of interest. There's periodic checks that are done to confirm if the conflict has been resolved with those specific firms. There is also an issue around similar and successful matters as a principle of allocation criteria, where matters are related. They're given to the same firm who have had, for example, one firm issuing 180 contempt court applications against the CEO, for example. It is obviously prudent to make sure that it's only one firm that is dealing with those, because of so that those issues can be managed optimally. So there are situations where a firm has previously dealt with a matter successfully, then they're given similar matters, because obviously in instances where matters are urgent, you do not want to start your briefing process from scratch in terms of making sure that firms having to understand the mandate of the RAF and all of that. Then you obviously have continuation of legacy matters from a previous panel. You have matters that were carried over that needed to continue. Next. Yeah, I think we have those main issues where it's whether it's conflict of interest. There are also instances where there's just no agreement in terms of, or alignment in terms of the legal strategy. Whether it's, then there are those that have got issues of non-adherence with timelines, and we've had instances of firms that were not available due to agency. And I think we also, in the next slide, Mukiti, I think this is just the list around some of the firms that are on the panel where there are conflict of interest issues. So there was an expectation that there is a process that needed to be followed in order to rectify that. Next. And then we have specific firms where they were, specific issues that they had difficulty with. You had one firm, for example, refusing an instruction involving an illegal immigrant because they believed that illegal immigrants are entitled to compensation. So that on its own, it becomes a difficulty from an legal strategy alignment perspective. So we've tried to also articulate those. Next. Yeah, we've also provided transparency around volumes per attorney, and also indicating context around some of the volumes that may look, particularly on Mpoyane Lidwaba, for example, where we had those 180 contempt court applications which had to be allocated for purposes of practicality. And thanks. Then we also attempt to provide the list of critical matters where some of these firms are dealing with, and this obviously are matters that go on for a longer period, and I think that's what we have tried to show in the list. Next one. And then we also demonstrate the successful cases per attorney, so that there is also an appreciation that they've also succeeded in significant matters that have gone over a period of time, which also has cost implications in favor of the fund. So the committee will be able to look at that. And then we also obviously then show the litigation and legal cost as was provided to SCOPA. And then here we also just provide a bit of context that the significant portion of the payout is to disbursements to counsel fees and not necessarily to the attorney fees. Specifically, you'll see there, for example, in the case of Malachi in 2023, of the 9.3, the attorney fees would have been 9.3 million, and then the council disbursements would just been just over 30 million. So I think the trend continues across the periods. We also reflect on the issue around default judgments, and we, in explaining default judgments, we thought we should explain it in context by bringing to the attention of the committee that for example, if you see in the financial year 23-24, the default judgments with 3% of the claims that were settled by or paid out by the RAF. Now maybe I must pause here a bit to explain that the main key driver for the strategy of the RAF post the 2025 strategy is essentially to move towards settlements by agreement, because ultimately the only way to avoid litigation costs is to increase the settlement by agreements. Now, the legacy problem of the RAF is that the number that you see, that is settlement by agreement, for example, that is 80% in 23-24. That number in the period between 2015 to 2020, that number was hovering in the 50% range. Now, that was the main issue. Then it meant that the balance of that was being handled in court. And that obviously shot up the litigation cost. Now, the approach, the new approach was to then say, how do we move away from a litigious operating model, focus on settlement by agreements? And then, of course, that is clear that has succeeded, but it certainly is not enough in terms of averting some of the default judgments that we see, and I think we'll explain how default judgments materialize. But I think, like we were saying, even in the engagement we had with the Deputy Minister yesterday, that it is the correct strategic trajectory to focus the fund on settlement by agreement. In other words, we must put all the resources we have to focus on that. We should not be tempted to throw out the baby with the bathwater because there is 3% default judgments in the settlements, and I think that's the point that we're making. So I think if you go to the next slide, we then explain that although default judgments are not desirable, we must properly characterize them. As we indicate that even in a default court, the judge is only allowed to grant default judgment after hearing evidence. The purpose of hearing evidence is to enable the judge to reach a decision that a valid claim exists in law. Now, we also provide examples where a default court judge would have dismissed the matter because a valid claim did not exist, or examples where a default court judge would have granted a lower amount to what has been paid for by the plaintiff. Now, of course, we also provide a case where the full court held that a court cannot act as a mere rubber stamp for the parties. Now, the problem we've obviously been having is that there is obviously a characterization of default judgment as some expenses or expenditure in vain, which in fact is not correct, in that this is still claims expenditure. But as I've said, it is a process that we must work towards, and in terms of optimizing our operating model. If you go to the next slide, Mukiti. So we're saying that payments are made pursuant to a default judgments are therefore or not expenses or payments made in vain. And we had this engagement with the AGSA in 22-23 financial year, where they also looked at whether they could fit the fruitless and wasteful expenditure parameters, and it clearly did not fit. Now, additionally, there is a process that court orders that there is a process internally that they are then taken through. An instances where there are problems, there is a rescission application that can be made in cases where there are fraudulent or overstated court orders that are grossly overstated. But I think the principle should be whatever we do, the process must be to continue on the trajectory to move to capacitate towards settlement, because we should litigate by exception. And I think that should be the principle that we should move towards. Now, of course, we must continuously enhance the capacity of state attorneys to ensure that there is optimal performance. There are currently initiatives that are on the go to recruit administrative staff, paralegals, and admin secretaries in particular to support the state attorneys. We are optimizing our block settlements. This is the key initiative behind the settlement by agreements that you have seen, the percentage that has increased there. Now, we are also participating in a key project that we believe will be a key game changer in terms of court-annexed mediation. It's a process that we started at the beginning of our strategy on our own, but it didn't go very far. But now that the judiciary is involved, we believe it can be a game changer that will also use to drive settlements. You'll see that some of the root causes are mainly around court directives, because in the main, default judgments are mainly a Gauteng problem. You'll see that in the numbers. I think there have been challenges that we have been having around some of the court directives that have come out of that particular court, and we have a coordinated approach that we have now with the judiciary, particularly as a result of this particular mediation project. Now, we also have a specific challenge, Mukiti, around huge challenges to some of the administrative decisions that we have made. Whether it is the decision of minimum requirements for lodgement of claim, that decision has been challenged to an extent that those whose claims are rejected go and issue summonses, which then obviously create a situation where there is an upshoot in some of these summonses. We know about the non-payment of past medical expenses. These are the key drivers of even these contempt applications that you have seen, because it is these decisions that every strategic change that has been made to attempt, the minimum requirements is its main objective and purpose is simply to ensure that we receive claims we can do something about at a basic level, and that has been challenged across the board. Now, obviously, we can't overemphasize the need for finalization of legislative reforms, because all what we have been doing is to work within the current legislative framework, which I think has got serious limitations that I think have been traversed before this committee. Next, I think this will also dovetail with some of the issues I was talking about now in terms of the status of some of the claims. Let's go, Mkiti. Now, the first part is on the outstanding personal claims. and direct claims versus the legally represented claims. But first, the outstanding personal claims. The trajectory of personal claims, you will see that pre-2015 to 2020, that trajectory has always been upwards. The personal claims that were coming into the fund were simply out of control, which essentially created a huge backlog that at the beginning of 2020 we needed to deal with. Now, you will see that it is only from 2023 that you begin to see this come down. In fact, from the beginning of the strategy, we started to halt the rate of increase, but it has started coming down. And even the unaudited number of 2025 is still showing a decrease. Now, why has this happened? Amongst others, the main root cause, as we've indicated before, has been that the outstanding claims is a factor of the number of claims that you register and those that you are able to finalize and settle. Now, in the circumstance where we were receiving and lodging claims that we could, with insufficient information, that we could do very little about, all it did was obviously then escalate and inflate the liability and then increase this outstanding personal claim number. And of course, you'll see that the direct claims also have gone down because we simply, the reality is that the current legislative framework is not designed for direct claims, because as we have explained here before many a times, that in order to get your claim, you essentially have to sue the fund, and the only way to sue the fund is you need to be a lawyer, and that's the difficulty. So the expectation that there will be direct claims coming in droves is not realistic in the current legislative framework. I think that that must be clear. Now, the other, if anything, you don't hear anything in this presentation, this next table is quite important, because it is also at the core of what we were trying to derive in this strategy, that of the claims expenditure that we receive, or rather the fuel levy amount that we receive, the significant portion must go to the claimant. Now, if you look at where we are now, in 2024-25, that's the unaudited number, we are at 88.6%. That is compensation percentage as a percentage of total claims expenditure. It means that the cost to expend the compensation is only about, or what we call administrative costs, are just around 11%. That's the number that was at the core of the problem of the RAF. Now, to then reduce it from where it was in the past to 11%, then you need to understand that there is a shrink of the administrative cost, of course, that was going to various third parties in the past, and I think that is at the core of the problem. But it is the correct strategic trajectory that we need to follow, and it aligns with settlement by agreements. Because the moment you settle through agreements outside of courts, that's the number you're going to see. And it is that we must continue to drive. If there are challenges in the operating model, I am yet to find a strategic choice without inherent risks in implementation. And the correct question always to ask should be, whether the strategic trajectory that you're on is the correct one. Are you focusing on the right goal in the context of the fund? And I must also emphasize, Chair, that the committee is well aware that the RAF has not received any fuel levy increase over the past 4 years. Now, the last commission of inquiry, pre-democratic era, the Melamed Commission warned at that time that there is going to come a time where there is going to be an irresistible opposition to any increase in fuel levy. And he says, when that time comes, what must happen is we must do exactly what happened with when the insurance industry collapsed. In other words, you need to restructure the benefits structure of the fund. The problem of the RAF is not the funding, it's not on the revenue side, it's on the benefit structure. And that is what the legislative review needs to assist. And I think the initiatives, the cost-saving initiatives of the past 3 years inevitably will have short legs, and I think can never be sustainable until we have a lasting solution around the legislative intervention. Now, I think the other issue is the settlement time, turnaround time. We said before, I think when we came before this committee, that there used to be a specific target in the strategy of the RAF to settle claims in 1,440 days in an APP. Now, as a target. Now, that then explained, so it meant that when people achieved in 1,300 days, you could easily get bonuses and all of that. Now, that inevitably then created the perfect storm that we had to inherit.
For you, just hold it there. I'm seeing a hand there.
Yeah.
Chair, thanks very much. Can I ask, I know the RAF had prepared for this presentation. And I know that they've said they presented some of this information to SCOPA. We never requested this information. And I thought that the chair of the board said after the 17th, they'll come back they'll come to share with us. You see, because we can't discuss this item in this way. And I think that the deputy minister also said they're looking at other things, so they will discuss properly those issues that are there. So I think my view is that we need to park that part of the discussion and have a meeting of because this was a special meeting to discuss specific issues, which I think that the board chair touched at the beginning before we moved to the second part. So this part of the discussion or of the presentation, I think that I suggest, Chair, concretely that we park it. We park it till the 17th, because I think it must be discussed in a proper way, not in the way that we're doing.
Thanks very much.
So that's my suggestion, Chair.
Yeah, I think we're going to allow colleagues to finalize because in that order.
Yeah, let me conclude. I think I was at the tail end.
Don't be intimidated. Just
no. I was at the tail end. So as I was indicating that that was the target at the time. We, over the past 3 years, since the introduction of the RAF Form 1, I mean the minimum requirements, we have seen that improve to around just over 300 days, although we still, in our APP, put our heads on the block in terms of making sure that we settle claims within 120 days. That remains our target. That remains even in the 25-26 APP. And the final question, I think, around this area that were asked was around the cost of the claims that are settled currently in our books, and we say that that is the RNYP. That's what we call the RNYP in the RAF. and that amount is just over 10 billion. Again, it's another a number that has been on the increase over the past the past years. I think you could see that it only began to drop when since the implementation of the strategy, and had nothing changed, that number would have been 51 billion at the currently. Next. Yeah, I think that's it. The copy of the advert. I think the chair of the board missed to talk to it. Thanks.
Thank you, Acting CEO. Chair, the last matter is still part of the court papers, so that initial disclaimer applies. We will come back once the matter has been heard in court accordingly. Thank you very much.
Thank you very much. Thank you very much.
There's a song, Chair. This is my story. This is my song. Indaba yethi phela lapho.
Diyabulela. Now, colleagues, yeah. I know all honorable members are going to speak. I need to make sure that we operate in a fruitful manner in terms of efficiency. But just before that, I need to caution members. You may be having specific interest on a particular issue, but that does not mean other members are not interested in a particular issue. I think that's important to underscore, because when others are asking, because it might happen, you must not be impatient. We must allow everyone to ask what he feels comfortable with, in line with the framework of questions that would have sent through the entity. I'm going to take hands, colleagues. I'm taking one set. Let it go. Yeah. So now that you are all going to speak, we are going to speak in this manner. Honorable Kubeka, you will start. You'll be followed by Honorable Mabena. Honorable Mabena will be followed by Honorable Skwambane. Honorable Skwambane will be followed by Honorable Kobe. Honorable Kobe will be followed by Honorable Maduna. This will be the first set. The first set. You are going to be allowed 3 minutes to speak, ask questions. From there, on that particular set, I'll allow you a follow-up when you're answered, and then we'll move to the next set. We're going to start on that manner. Honorable Kubeka. Honorable Malmacha, if you can stand in. It from where you are seated. Thank you.
Thank you, Chair, and greetings to the board, greetings to the RAF team, greetings to the Deputy Minister, greetings, honorable members. I think before I ask any question, when it comes to the issue of RAF as a whole, I did at some stage ask that I was asking the SIU specifically, because I know that bulk of what we are here for stems from what comes from that preliminary investigation into RAF by SIU. The question was, if the SIU comes to Parliament with an incomplete investigation, do they not fear that the media will run with incorrect narratives about individuals and about the entity? And the answer I got was that the people will have a right of reply. Now, given the amount of media attention that the issue of RAF has gotten, there's a lot that has been said based on what the SIU report had mentioned. And the people who are actually involved in that SIU report have not had a right of reply. And we find ourselves in this situation right now where the media has run with their own narrative about what happened. And dare I say, bulk of what has been said, we have not had a response from the people or the person or the main character in the story. Now, I think I asked this before, and the Deputy Minister did answer it. But from where we stand, I think I'm still of the opinion that it seems as though the CEO was being silenced by a way of how this thing happened. Because before he came to speak in Scopa, and and just for those who do not know, I sit in Scopa as well. So a day before the CEO comes here, he's told no, he's put on special leave. And when the board realized that they made a mistake in saying that no, the CEO must go on special leave, they go and rescind the decision and they make another one where they put him on suspension. And when you ask the reason for that suspension, you're told no, he refused to appear before the board or before Scope or before Parliament. Now, when you go and you look at how this thing happened, it looks too opportunistic, Chair, that you will say no, he did not want to come before Parliament. When we know the acting CEO came here and said to us that no, I flew down with the CEO is here in Cape Town. He was ready to come and speak to us, and then he was told at night, I think it was around 11, that no, you are no longer coming, you've been put on special leave. Now, for the board to then rescind on that decision and then put him on suspension now, or precautionary suspension, or whatever they will call it now with those fancy words, they're putting him on that precautionary suspension after they had said to him that he mustn't come to Parliament. I think, Chair, the question then would be, could they clarify that sequence of events? Because right now, it seems to us, or from where we stand, that the board put him on special leave and said he mustn't come. And then they go and suspend him for not coming. So I would just like to know, what is the rationale, what is the idea, or what is the sequence of events in that situation? And then, given the presentation that we just got now, I have to ask, Chair, the question, another question on the Discovery Health versus RAF case. How much was Discovery claiming from RAF? And I see that one of the successful cases was Discovery Health versus RAF. I see that the lawyers that were involved there was Malachi and Co. and Ponyana Letwaba. Now, Chair, if that is the case, the next question then is this not the main driver behind the fight over Ponyana Letwaba attorneys and Malachi and Co. to say that no, they've received bulk of the work that comes from RAF, given that they challenged Discovery and won? That is a question to RAF now. Chair, I would like to recall, and I'd like to remind everyone here, that when we last sat, it was said that the Deputy Minister and the board said the CEO is not guilty of anything. And then we asked, why is he put on forced special leave? And we didn't get the question, so I'll ask that again. If the Deputy Minister and the board said in this House that the CEO is not guilty of anything, why was he put on special leave? Why was he then later or subsequently basically fired? Suspended, sorry. The next question will be,
I may have been out, but I think you are bordering on exhausting your time now.
Okay, thank you, Chair.
And I think from now I'm going to put my timer on now.
Okay, Chair.
Sure.
And then you just put me off now, Chair. The building that and one of the buildings that is the it's on that presentation. I wanted to ask, who do these buildings belong to? I don't remember what slide it was. Oh, that slide there. That slide. I see there's the Johannesburg building. Who does that building belong to? The head office in Johannesburg. Who does that building belong to? Thank you, Chair.
Thank you very much. You are followed by Maben.
Thank you very much.
I'm starting the time.
Thank you very much. Okay, I think according to your report on slide 9, you do admit that the entity has a higher vacancy rate of 17%. And I think that issue for me is a bit of a challenge because it speaks to an entity that has a bit of instability in terms of leadership. So there is also a number of C-suite positions, and a total number of them is about 10 of them. Well, the entire complement of the C-suite is about 10, but a significant number of that is vacant. Now, the issue now is that, firstly, we have a situation where the head of claims operations is vacant. And as a result, effectively, that role is performed by the CEO. Now, the other issue that we have with that is that the chief claims officer and the head of claims operations, the CEO assumed those functions of the chief claims officer, given that the claims officer, or given that the head of claims position is also vacant. But also, again, Mpho Manyasha, the head of office, or maybe the chief of staff of the CEO, she also currently serves as the acting chief corporate support officer, through which she oversees the corporate communications and people management. In effect, therefore, meaning that she also acts as road accident funds head of human resources. Now here, maybe are the questions that I want to ask. Number one, what job level is the head of the office of the CEO position? And given that, as I said earlier, that Manyasha was permitted to take up the position as an acting chief support officer, that's the issue we're dealing with. And then also, what changes in vacancies and acting positions in the road accident funds organization structure have occurred since August 2024? And when the latest annual report was signed off, and when was the latest annual report signed off? And then maybe on the same issue around the issues of vacancies, how did the board sign off the road accidents funds 2023-2024 annual report, given the clearing concerns as presented in the organizational structure alone? Do you, as the board, have the necessary foresight in terms of RAF and identify, do you potentially see any governance concerns and issues within RAF, given some of these issues that we're raising here? Another issue is, Chair?
Yeah, out of time.
Okay, let me conclude. What is the function of the chief investment officer, given that the road accident fund is not really meant to have, or does not really have assets to manage? But also, if you go back up on the structure, there is a head of asset management within the organizational structure as well. But then, as I said, the issue of the 17% of the vacancy rate is concerned in slide 9, but also the subsequent issues that I've raised are regarding that issue.
Thank you. Time up. Who's following? Squamba.
Thank you, Chair. I don't know because I wanted to have a one-on-one session with the person that I wanted to ask a question, but I can see that it's actually taking.
Who do you want to ask?
I wanted to ask the
No,
suspended.
that will be done later. For now, we're asking the board. If you have no question against the board, it's fine.
No, okay, I don't have any question for the board, but just to make some remarks, to say we welcome the RAF 101 lecture that was given here today. It was a sort of we are in a lecture hall. But what needs to be known and what the public must know.
It was like I'm in a lecture hall.
Yes.
Not we.
I'm not alone here.
Not us.
Yeah. So, but by the way, Chair, you know, lying is a problem. When you lie, it's a problem. And in front of me here, I see old people here, older than me enough, that I can say when I look at them, they are at the age of my parents, and I don't expect old people to lie. Why do I say that?
On a point
Chair?
of order, Chairperson.
All right there.
The rules of the House, Chair, apply in a committee.
Yes.
We are a sub. The committee is a subcommittee of the House.
I wanted.
And I think that the board must be protected. We are here to account.
I wanted to come there. Look, Kwamba, I know you may be in this committee for the first time. We subscribe to the rules of the House to the latter here.
But it's not the first time I am attending committee meetings.
No, I'm saying, yeah, we subscribe to the rules of the latter. So the decorum is important. For sure, you would have heard I use this word several times. If this...
Okay, they're not lying, they're misleading.
Yeah, if you feel misled, it's fine, but don't label them as lying.
They're misleading.
Okay, it's
yes.
fine.
So I'm using the correct word that the deputy minister may be comfortable of. They are misleading.
So are you done?
No, I'm not done. There's one thing that I want to say to them.
Chairperson, on a point of order.
No, but my time is being eaten by the deputy minister.
Controlled by me. So you have no right to speak
I don't
about.
know.
Your time is protected by me.
Okay.
Yeah. If you can switch off, Minister.
Chairperson, when we invoke the rules of the House, it's not a matter of comfort.
Yeah.
We are invoking the rules of the House, and all I'm asking for is that we be engaged in a manner which is conducive for engagement. My outlook then we can do that.
No, thanks, on DM. I think I've dealt with that particular part already.
Yeah, thank you, Chair. And I don't know why the deputy minister is going back there because we're...
No. Proceed, my chief.
Yes. So, Chair, why am I saying the board is misleading? They appeared before SCOP in the absence of the suspended CEO. And in that very same meeting that they've attended, the reasons given there for the suspended CEO not to attend the meeting was that you were actually not aware of the meeting here as a suspended CEO. So now the now acting CEO in that meeting says the suspended CEO is actually around Cape Town, ready to attend the meeting, but was not informed of the meeting, by the way. All right? Okay, we leave those things now. They go and suspend him immediately after that meeting that he did not attend. And the reason provided that is that they suspended him on the reason that he did not appear before SCOP. And now today here, the chair of the board says to us, the reason they took a decision of suspending the CEO, it is based on the legal advice that they got from their legal team, which is not in detail or what is actually detailed in the legal advice. But one can equally tell to say there's a level of
misleading or a deliberate way of wanting to mislead the public with reasons behind suspending the CEO. But when that time comes of asking the CEO questions, I think I will have enough time to ask the CEO questions. But if also you will be not able to respond to the questions that I will put before him, based on the fact that the matter now is before court, you will be able to indicate that I won't be able to answer to this question because the matter is on court. But what I want to register is that we must stop misleading the public with serious issues that the public may want to have interest on them. Because here we are having people before us who continuously come with big reports like that. And while serious issues that brought us, my understanding of this meeting is that we wanted to understand why the CEO was not part of the meeting and at the later stage was suspended. And we have been given a slides here of a lecture hall. Thank you, Chair. I think I will come to ask the CEO some questions. Thank you.
Colleagues, maybe I must clarify this matter also. We did not ask them to present only on the suspension, so that I must not create impression also that we are the ones who created a problem. You would have asked a set of questions that they actually had to respond to, including the leases, the vacancy rates and all that. That is why, by the way, I allowed them to present the report, and when Honorable Montana was intervening, I would have then said, let them complete, because they did not create the report out of their own imagination. It was out of your own directive. So I needed to clarify that. Honorable Kobe.
Thank you very much, Chair. Chair, I'd just like us maybe to start with the slide where they speak about the vacancies that are open. Right there, Chair. I'd just specifically, so the Chief Claims Officer is vacant. Just like for them to clarify for us, how long has this been vacant for? Who has been acting in that regard? Because we do know that the CEO has been acting in that regard. Who's playing now oversight in terms of risk? We have a head of risk in here, right? Do we have a head of risk or head of internal audit who's able to keep checks and balances? Because you can't now play a person who approves the claims, but you still also need to play oversight. It can't work. You can't be a player and referee. So I need to know in terms of risk management within RAF. I think that question should be directed to Mr. Nyama, if I'm not mistaken. Is that the head of internal audit? This gentleman in front of me. Do I have your name incorrect, sir?
Yeah. Through you, Chair, if I may.
What would I clarify? The name?
The CIOA. It's Radiquen. It's just behind me on my left as well.
Thank you.
Apologies, Chair. Apologies, colleagues. But yes, Chair, I'd just like to know in terms of that from 2022, who's been playing that role and who has then been playing oversight. And to the board, for me, I think this just shows a lot of irresponsibility. But I'll ask another one. The Chief Investment Officer, Chair, it looks as though it's on hold. According to reports, is the position not currently, held by Mr. Sefutle Mudiba? And if so, what were the vetting processes to vet him as an individual who should be responsible for such a portfolio, given how he has left from his position in the city of Johannesburg as a councillor? Just like to know if any vetting processes in that regard have taken place on the end of the board. Chair, I'd also like to ask about in terms of the deviations. I know they've given us a list of law firms. They've given us Malachi and Mboyana and Ledwaba, who have who have received a disproportionately huge amount of work from RAF. I'd just like to know, with regards to the information that they have given us, is it in fact accurate? And also, can they tell us about Gertnel attorneys and if any deviations have been enacted from their end when they then required services from Gertnel attorneys?
Thank you for sticking to time. Honorable Maduna, you are last on the set.
No, thanks.
I hope
Chair.
you'll do likewise.
Hey, this 3 minutes is small, eh? No, thanks, Chair. I will try as well and be as precise as possible. Chair, no, we welcome the presentation. Being is that it may, I think, as a remark, because we also happen to sit on Scopa. I must just say that I'm if in line with what I think one of the speakers would have spoken about it. I'm interested to see the local opinion that would have advised the board to put the CEO on the basis that they were bringing forth to enforce the special leave, because I've never really saw something like that, especially with the regulation that speaks into the issues of special leave. But being as it may, I can say that they took the lecture that we provided at Scopa and they subsequently, according to the reasons that they were providing, because if you're providing the reasons that they were providing, then it means you must suspend someone, you must precautionarily suspend someone, of which I believe it's what they ended up at the end of the day doing. But being as it may, Chair, I just have a few questions. One, on the issue of office accommodations to RAF, especially the ones in Joburg, because I think in the public domain there's a lot of interest around these issues, and we need to make sure that there's a clarity around them. One, I just want to check, before the RAF moved to those offices, where was RAF, which offices they were using, what were you paying for those offices, in the current offices that you moved to that are said to be owned by the pension fund. Two, there was an allegation that initially, I think it's there in the public domain, that RAF would have not taken the company that would have been recommended by bid adjudication. I just wanted to know, is this true? If so, was that company cheaper than the one that was taken? Because I believe that it's for a good cause when you are renting offices from the government employees pension fund. Two, I want to check on the issue in line with the previous speaker. I want to check in the issue of the chief claims. Was board aware, because I believe that the person have been not there for about a year or so. Were you aware of that the person is not there? And I believe that did you give approval to the CEO acting as a chief claims officer? And as well, what was the view of risk management and internal audit? Because I know there's a process of risk management that must be done annually, which is what internal audit use when they develop a risk-based plan. So that's my other question. On the GRAP dispute with HE, I just want to check, because I believe, was this a board decision? I believe it was, but I just want to ask, because we need to put things into perspective now. Was this a board decision, and who was the legal firm? And that would have given the advice that HE can be, you can take HE to court on those bases. And is that the same legal firm that represented you on the case? Yeah, and perhaps let's just look into
conclude.
Yeah, Chair. As I conclude, Chair, I think, Chair, my worry as I conclude, which is I think it's around the last question. Did board know that RAF did not have? Was it aware of the information that there is no head of legal under Silapa? And then, lastly, as I conclude, Chair, I think in the issue of the suspension of the CEO, I say that in many slides it's sub judice. But I must say that it really worries me, because in the public domain there are many things that the CEO was suspended because there was a podcast, I think, where he spoke about the conflict of interest that involved judges, and I think RAF has been doing a great work, especially with the issue of Discover. I saw that they won the case, so I must say that I'm really worried, because there is a perception that is being created.
Thank you very much. Not that I'm protecting judges, but your time is up. First set of questions, DM, if you could.
No, thank you very much, Chair. I think largely the questions are for the board, for the board to respond. Suffice it to say, Chairperson, that at that SCOPA meeting, we, for the purposes of clarity, the SIU has not briefed the ministry on its matters. And that meeting is scheduled to take place next week, Wednesday. And we will get an update on the part of the SIU. Honorable Gupega makes the comment around the suspended CEO not being guilty of anything. That remains the understanding of the ministry, that the special leave, amongst others, was to give space and time for the suspended CEO, now was not suspended at that point, to engage with the processes of the SIU. So I reiterate what I said in that committee meeting, in this committee's meeting, and in the statement that we released as a department after having been informed of this decision. The only expectation that we have is that if there's an SIU process underway, all affected parties, or all those who will have to present information or present themselves to the SIU should do so in order to ensure that the processes run their logical course. And then lastly is to indicate that rightly or wrongly, this issue is not without precedence in this parliament generally, in that, and in the SIU operations as I understand them, that a preliminary report of the SIU has been used before and can be used for the purposes of onward use by other bodies, including but not limited to law enforcement agencies, to then investigate on the basis of that report. So it's not without precedence, but I'm not privy, Chair, to the content of the SIU report and when or briefing, but at the point at which I receive that report and briefing next week, Wednesday, I'll be in a better and stronger position to actually know what is going on. And so I think that because Honorable Gupega, having been in the SCOPA meeting, I think he also then places another issue on the table, and for me to clarify that as far as the ministry is concerned, there is no basis to the claim that the suspended CEO was being suspended, on the basis that, one, I was informed by the chairperson of the portfolio of the standing committee that he is in receipt of a letter from the suspended CEO that he would drafted by his legal representatives, and I'm sure you can share records that he would not be attending the committee meeting. It is, amongst others, one of the reasons why, one, I said the board must attend the meeting, because I do not agree with the position that the board took, and I stated that up front. It was wrong for the board to take a decision to say that they would not be attending SCOPA. But they subsequently rescinded that decision to attend SCOPA. And I'm advised that the suspended CEO, through his legal representatives, had said that he would not be attending. So it is up to the board then to give you the full and nuanced details of the processes of that meeting. And I think, Chair, for the purposes of the record on the, because SCOPA had a deadline upon which it had wanted to actually get a report and a presentation, is that I wrote to the board on the 23rd of May, wherein I said that RAF is hereby directed to honor the SCOPA invitation to appear before the committee on Wednesday, 28 May 2025, and in that meeting ventilate the matters that you raise in your letter. And the response I received from the chairperson of the board is that, having interacted with SCOPA and the SIU, the board had resolved that they would now be attending the SCOPA meeting. So I stand by the response, therefore, for the purposes of clarity that I gave at the SCOPA meeting, that I do not believe that the CEO was being silenced if Parliament was in receipt of a letter saying that he would not be attending the meeting. And then is to also then indicate that my understanding was that this decision was taken in a board meeting which commenced at 8:30 or thereabout in the morning on the day upon which the special leave was granted. And therefore I do not believe, Chairperson, that we can be associated with silencing, because the decisions would have been communicated through the day. So in the event that there's any ambiguity, the basis upon which I made the claim and comment I made in SCOPA is that one, that that's the information that we had. And up to now, it has not been revised, and therefore I still stand by what I said. Thank you.
You can pass the bite. You can pass the bite.
Thank you very much, honorable members. I will deal with questions that were directed to the board. The rest of the questions, which are mostly operational, the acting CEO will deal with. I think the first one is about the chief claims officer position. Oh, okay. No, the first one is about the vacancy rate. What was the board's position when they signed the previous annual report? Let me be on record to state that the board has been, on a continuous basis, raising this matter of the high vacancy rate, particularly the critical positions, the executive and senior manager positions. And we even directed the subcommittee of the board, REMCO, to actually prioritize this matter. We were told that most of the key positions are in progress, and we are aware of that, because the chair of REMCO was part of that. At one stage, I was also part of the panels that started dealing with the recruitment of executives. But because of the nature of the RAF, there's a whole lot of risks around people, attracting people, critical people or experienced people into the RAF. So there were a lot of challenges in attracting the people who were competent to fill these positions. But the other problem that was given to us was the Section 189 dispute with the unions. If we recall correctly, in the past, as part of the 5-year turnaround strategy, the RAF implemented, it reviewed its organizational structure and then started implementing when it was approved. Then there was a dispute between the labor in terms of some of the conditions affecting their members in the implementation of that structure, emanating from Section 189. So the implementation of the structure was actually placed on hold pending those disputes being handled in the various labor fronts, as well as just to try and resolve that matter. So those were the main reasons why those issues were not fast-tracked. But the board was on record to actually say that we need to get them out of the way. So currently, we've given them at least 4 months to ensure that all the critical executive vacancies will be filled. So we should come back and be able to give some responses, because we said in positions that have already been out in terms of the recruitment process and we failed to actually attract the right candidates, we need to go out and headhunt, and that would fast track the process. So hopefully that will fast track the process. And then the issue around the chief claims officer position, again, these risks that are raised by the honorable member were raised. We are on record of raising those issues around segregation of duty, as well as the fact that if you are a CEO and you are acting in a position that reports to you, so if there's a dispute on issue, who actually presides in terms of clearing that matter? Those questions were asked. And the reasons we were given to us by the CEO was, first of all, that he was the only person who had the correct competence because of the RAF being a very complex organization. Remember that position requires somebody with a legal mind as well as a medical experience. So the answers we used to receive in the boardroom was that currently he's the only one doing that, but we were aware that there were, processes, that were ongoing in terms of filling that position, but the challenge is that they couldn't get the right candidate to actually deal with it. But currently, the position is now temporarily being occupied by one of the regional managers, because you have people within the regions who actually process claims in their managerial functions, and they should basically be able to assume this position, because also you need to ensure that you expose other managers, in acting in senior positions. So right now we have one of the regional managers caretaking that position. Hopefully then they will fast track the filling of vacancies, again using the possibility of going out there in the market and start headhunting. I think the last question around the board. Or did we approve of him acting in that vacancy? No, it was never put before us to approve that. Like I've just said, that we had concerns around that. I think the chief internal auditor will also talk to us, because we were given assurances that there are checks and balances in ensuring that nothing gets irregular is actually happening in that environment, and that the auditors, the processes gets audited on an annual basis. And then lastly, regarding I think the question was answered in terms of the board decision around the AXA matter. I think it has been deliberated on a number of occasions, but the actual legal firm that was appointed, I think that became, the ambit, fell within the ambit of the CEO and the executives. However, the board is currently going to a process of reviewing looking at other options that will actually assist it to get out of, court in a very technical manner, because the issue around this is that the technical dispute remains in terms of the fact that we don't have a relevant social benefit standard in which the organization can use in accounting for its claims liability as well as the associated expenditure. So the board is going through that, but we were given 21 days to actually do a risk assessment as well as an impact analysis if we basically go out of court and find other amicable ways to resolve the problem. So we should be able to come back and give direction after 21 days, because the ministry, and we appreciate that, is willing to work with us in terms of progressive decision making in terms of coming out of that once we've done a proper risk assessment and impact analysis, because there's going to be very serious impacts on the business of RAF, because there are other legal implications around that decision. I think, Chair, I've answered all the questions relating to the board. I'll allow Mr. Lucaroni to answer the rest.
Thanks, Chair. I think the Chair also answered a few questions around vacancies. I think I'll just pick those that I think needs more emphasis. I think the first one, Honorable Kubeka asks about the impact of the discovery versus the RAF matter. It's a huge matter for the RAF, for the sustainability of the RAF, not only from a medical claims perspective, Honorable Kubeka, but because I think this is the judgment that affirmed that the RAF is not an insurer. So it's very significant in that manner. Although we have not quantified the specific claims that might ensue from discovery specifically. This is bigger than discovery, that there are also other medical aids that is the avalanche that will be opened around medical aid schemes that will also come and seek this reimbursement. So this is a huge judgment for the sustainability of the RAF going forward. So I think that context is important. Of course, one cannot really comment further around whether that then amounts to the victimization or whatever thereof around the firms that you have indicated in question. But it's a huge matter for the RAF. In terms of the Johannesburg building, indeed, it's owned by Moana, as indicated there, which is essentially a GPF owned building, and I think that's how the lease agreement was signed. It's with in that manner. I think that's clear. The other issues related to, I think there are other questions, I think, from Honorable Mabena that were also I think addressed by the chair. As we have indicated, there are only 3 in the main vacant positions at the EXCO level, and I think we must add that on the Chief Claims Officer, there was a real challenge in that space that resulted in the whole EXCO going into the regions to intervene to an extent that the CEO saw it fit to take full responsibility for that position because of the risks that emanated. It was a crisis that was there at the time because of the issues that had to be dealt with at the time, and I think it was always meant to be a temporary intervention because, as we have indicated, the position, there was a lot of work done to try and fill that position that which attempts failed. And of course, we can confirm that there is someone who's acting in that position at the moment. Yeah, I'll talk to it. Now, the other questions, I think, I think Honorable Kobe also speaks about the issues of the acting of the Chief Claims Officer. I think I've spoken to that. The CIO position and the vettings that is done. I think we have explained this issue around background screening that is done, which was also done even in this case. Reference checks were obtained even from the city of Johannesburg. So vetting is more of a comprehensive process, of course, that takes place where we all subsequently submitted our vetting forms to the State Security Agency, which are still being processed even at this point in time. Now, of course, yeah, we don't brief Gert Nel, attorneys. I know Gert Nel is sitting behind your honorable self. He's a plaintiff attorney. Of course, he does plaintiff work, and he's one of the firms that get the. I think it's one of the top 2 firms. I think we presented in the past, in terms of the payments that get dispersed from the fund, but not as a corporate member of the panel. Now, I think the questions from Honorable Maduna around the issues of the Johannesburg lease, I think I'll ask the CFO to speak to that in terms of the specifics. I think, yeah, Bernice.
Apologies, Chair. If the acting CEO can complete his responses and inform the committee, because I just feel like transparency and divulging all information helps. What is the status of Mr. Mutiba at RAF? Because you speak of background checks, can we please just say everything?
DM, thanks for that intervention. You're going to have to be helpful, and you are not going to have to expect your senior to intervene for you to answer questions. That's clear, right? Now, you can't be, you can't apply austerity measures to answers. You're going to have to be as open as it can be possible, so that we do not have a lot of follow-ups in terms of questions. So where you have been asked a question, please, as the DM is saying, just flow and answer the questions as you understood it to be asked, not to want to be, economic with answers. Sure.
No, thanks for the clarity. Like I said, I understood it to be about this security screening, but the subsequent events around the CIO is that he has been placed on suspension as per the also resolution of the board. I think he's currently on suspension.
With effect from?
With effect from yesterday.
Yeah, you see.
Listen,
yeah.
You see, my apologies, Chair. Can we put things in their context? At a SCOPA meeting, SCOPA advised the board of RAF and the executives that it was in receipt of a letter from the city of Johannesburg indicating that Mr. Mutiba had resigned on the eve of the conclusion of a disciplinary process. But the information and the letter which came from Mr. letters said other things. Now, I do not understand why we would want to skirt over that matter, because it's substantive to the issues which are giving this follow-up meeting. And Chair, I want to say this to yourselves. It's the last time I'm going to intervene. But I hope this gives you a glimpse of what we are dealing with. You can't be speaking about vetting in your response and place it as substantively as that, but don't add the latest developments in their context that you are in risk, unless the board went and did something different on the basis of that suspension.
Yeah.
So this is, colleagues, the extent to which the problems at RAF are. So I'm asking, Chair, that they explain to you so that you don't come back now when something else arises with what's the status of this. Just put it out there. It's not a secret. It's an issue of governance. It's an issue of accountability.
No, DM, it's good that it is coming from yourself, that you are picking what is happening. Acting CEO, what you're doing is wrong. And it borders on being secretive to a committee of parliament. And I don't think we're taking that in kind. And I think it will be for the last time, not only to you, but also to your colleagues. We're not here to play. It's about just after 9 now. And we're not going to be sitting here listening to you, bluffing to us, telling us things not in context, when you actually know what is the context. I ask you, what is that context that you need to give, because the DM has intervened? You still, even in the eyes of the DM, still want to hide other things. And I'm seeing Honorable Kobe still continuously raising a hand from there. I plead with you, please answer the question so that we don't have to take follow-ups. You still want to sweep certain things under the carpet. Why are you doing that? Don't answer that why. Just proceed and give answers.
Yeah, Chair, thanks. My apologies, Chair, if I may come across as...
You are exhausting your daily limits of apologies.
Yeah, as I've indicated that in the matter of the CIO, indeed a board resolution was taken where and pronounced at the portfolio committee. And I think in the meeting yesterday I did indicate that that particular decision.
Announced to which portfolio?
I'm saying the last portfolio committee. I think the board, when the board presented, they indicated that one of the decisions that were taken was that of the suspension of the CIO, acting CIO. And I indicated again in the meeting that we had with the DM yesterday that I could not just, without applying my mind, because I needed to be the one that signs the suspension letter of the CIO, I needed to apply myself. And after even applied myself, I eventually signed the suspension letter of the CIO, acting CIO. So I think that
Hold it there. What do you mean? You want to tell me that what you are saying is that the board pronounced suspension to us when you have not signed the letter? Is that what you are saying?
Correct.
DM?
Chairperson, I would want to believe that the governance shortfalls in RAF are coming to bear, because the issue around the CIO has been a subject of discussion in those COPA meetings. And then my understanding, and the board is here, was they received a response from the City of Johannesburg on this matter. And as I said, we had a meeting yesterday. And up until yesterday, a board decision had not been implemented that the board had pronounced on, insofar as this individual is concerned. So I think, Chair, it is for the board to give you the sequence of events around it. But I would imagine that it's central to accounting to the committee, unless maybe ebuncaneni bami ngibona kafishane. But we are here because there's a suspension that is a subject of discussion. Following that, there is another suspension of the Chief Investment Officer. I would imagine that any response is supposed to be very frank and forthright about that. So that is, if I ultimately, Chair, just my misgiving. Can I ask the board?
I want to come there
to explain its
maybe
due process.
let me ask this in a particular context. The acting chair of the board was there. You are the one who pronounced this issue of the suspension. The chair of the board, obviously, you apologize, so we accepted your apology. Would then imagine that she was acting on your behalf. So the two of you can assist us here. Because this borders on whether we must continue to listen to you tonight, or we must agree that you must go home and pronounce on you. Because if you can come and lie to us literally, and it's the DM who must then, we don't do that, Kwamba, please. And you have the audacity to come, even want to sweep issues under the floor to the extent that you want the DM to be the one intervening. It speaks to your failure in terms of fiduciary duties. Now tell me here, according to your understanding, when does a suspension take effect to a person?
Chair, thank you so much. You are correct. We had a board meeting. It was on the 2nd of June. And we had a whole lot of legal advice that followed specifically on that day. One of the decisions that were taken was the suspension of the CIO. And mainly because we had full evidence of why we needed to suspend him. If I can mention that.
Deputy Chair, I don't want you to give background. I think we're enough with your background.
Maybe the answer is the 3rd of June. On the 2nd of June, we made that decision, and essentially, it doesn't lie within the board. In terms of delegation, that matter goes straight to him as the acting CIO to effect the acting CEO to effect the decision. So even if we've made the decision, the delegation to implement does not lie with the board. It lies with the acting CEO.
So you said with us, told us in confidence, and if we were to go to the public, said that the CIO is suspended, when actually he is not. Is it he or she?
It's a he. It's a he.
When he is not suspended.
Chair, the board made the decision and communicated that decision to the acting CEO. Please understand that the board cannot effect it. It needs to give it back to the acting CEO. And I mean, on the day when we made that, we made him aware of that. So we just can't sign his letter. Delegation lies with him.
Can you answer me here, ma'am?
Yes.
When you came before us,
we had already communicated that.
Can I ask you, can you stop interfering with me when I ask you questions? You are going to have to be respectful here. We are not playing here. When you came before us that you have suspended the CIO, did you have the copy of the letter of suspension?
Chair, I must just verify that. Yes, I do know that we had already given him
I'm saying, did you have the copy of suspension from the CEO? The acting CEO suspending the CIO?
The copy of the letter was issued after we've had the resolution. That letter was also made
given him, it was forwarded to him so that he could sign. So that letter was available. After we
I'm
had made
saying,
the
did
decision.
you have a signed copy that Donald Slamlela is suspended?
I can't sign it. It must be signed by him.
Who says you must sign the letter? Do you listen to what I'm asking? I'm asking you. Did you have the copy signed by the delegated authority in this regard?
Okay. No,
Can you not disrupt when I ask, ma'am? Can you switch that mic? Can you learn to be respectful, please? I'm asking you. You are sitting in a committee of parliament in a meeting that is viewed by the people of South Africa. You tell the people of South Africa that you, as the deputy chair of the board, acting obviously on behalf of the chair, and your board, you are communicating to us that you have suspended the CIO. When you do not have a proof that that decision has been effected, what is your take on that?
Chair, I take it that the signed letter, I didn't have it in front of me. That is correct.
So you would agree that you misled us?
Chair, if it's seen as a mislead, I want to apologize. That was not the intention.
Seen by who? Do you agree that
Chair,
you misled us?
I want to apologize.
Do you agree that you misled us?
Chair, let me say to you, I didn't necessarily see it in that way, but what is proof? The proof of the meeting is that we didn't have the signed letter at the time when we informed you.
Would you agree that you misled the Committee of Parliament by telling them that you have suspended someone who has not even received that particular letter?
Chair, I accept.
Okay.
To say I accept, it was not intentional, because I couldn't act on it myself. So I want to say I accept, but it was not intentional.
Suspension letter.
I signed it yesterday.
Ah. Is your matter, Honorable Kwabis? You want to say something?
Chair, I think I'm...
No. You are still coming. You have your set. You are coming.
Chair, I think we are witnessing in real time a pattern of the board of doing things a day before we come to the committee, things that have high legal implications. They have misled the board, they misled Scopa, and now every other slide on that presentation says the matter is under sub judice, because they were unable to tell us the truth. In their back and forth, they say Mr. Letwalo was insubordinate. He refused, point blank.
I think you are getting to the discussion now. Let me ask this last question so that to proceed with your questions. Colleagues, you still have your own time. Honorable God.
Sorry,
what is your intention about the acting CEO? Because that is an act of insubordination. Did you reflect on that particular matter?
Chair, from my side, I only had it yesterday when we were at the DM's office, that he only signed the letter yesterday. So that's really what we sort of got to know. I didn't know that he had not signed up to then. So that's just my honest answer. I only knew yesterday. I thought he had already signed it.
Did you reflect on that matter yesterday when you were with DM, when you learned?
Yeah.
Between yesterday and now, what is the decision you have taken about that particular act which resulted in you misleading a competent committee of parliament?
Chair, I will say we have to take it back to board. I can't make a decision myself. The board was there.
The question is, did you as a board, because you got that information yesterday as in the meeting of the board, and probably once again by the intervention of the DM, by the time you get that information, did you reflect about that particular matter, about the conduct of the acting CEO?
Chair, I think we each reflected, but we have not met as a board to make a decision. I think we did reflect, but we do need to meet as a board and make a pronouncement on that conduct.
I hope you'll still have that time. Yeah, proceed with questions through your DM. Sorry for those interventions.
I think we were at a point where the audit committee was going to provide a response on issues that had been raised. I think that was the last segment that was there on issues around the risk and the chief claims officer and the CEO being a referee and a player.
You can pass the bite.
Thank you, Chair, and thanks for the opportunity to comment. I think this question is probably more appropriate to Regal, Chair, instead of the Audit Committee. So
the question was put to you.
There is a context at which why the question was put to you.
Okay, and maybe Chair, can I please have the question so that I'm sure in terms of answering the question? I don't want to answer incorrect question, Chair.
When you say that the question is best as answered by someone, what is the question that you understood to be?
My understanding of the question that was placed before me was around the risk as well as the control around governance. So maybe to explain the lines of defense, you have the board, and the board have various subcommittees, including audit committee, regals, and amongst. Regal is your risk governance and actuarial committee. It focuses predominantly on risk matters, including assurance. But because audit committee have a responsibility by its statute, the Regal committee then report into audit committee. Hence, I was answering the way I was answering, Chair.
Internal controls?
The internal control, obviously, it's our CIOA who report directly into the audit committee.
So when the matter was reported to you, I'm trying to assist you to arrive home quickly. When the matter was reported to you, because the CIO deals with internal control, and my understanding and the context of the question borders on internal controls, what did you do yourself with that matter before you passed the bite?
My apology, Chair. I don't want to mislead the committee or otherwise. I would prefer to err on the caution side and ask the question to be repeated. Honorable Member, I apologize.
Your question? Yeah.
Oh, I think we asked almost the same question, but I can give context to what I was asking.
Do that.
Just to perhaps, I think, as an audit committee and a risk management committee, you do receive reports of internal audit on their audit of corporate services. I believe it should be annually because the risk level is quite high in that particular department. Now, I believe that you have received the report, and I believe that in the first few pages of the report, it states the organizational structure, the budget, and the current expenditure at that time. I'm saying the format of the report, and I'm sure you are familiar with what I'm saying. And part of that report is that it would tell you that there is the CEO is acting in this particular position. What was your take on that? That's what I'm asking. Because I believe that you were supposed to raise it as well, if you are uncomfortable with it or it was not within your risk appetite. Thanks.
Yeah, thank you, Chairperson. Once more, my apology. I think the question is much clearer. Thanks to the Honourable Member. And the Honourable Member is indeed correct that that particular report would have been elevated to the Audit Committee. I just want to clarify that within the RAF governance structure, an audit committee is not audit and risk committee, it's audit committee. However, the risk matters do have dotted line into the audit. The report that was provided in particular around this role of the acting chief claims officer, the reason that we were given were noted by the audit committee. And I think, in all honesty, we were quite comfortable with the reasons, given that that function was quite critical. We didn't see in the interim or in the short term why would the CEO not be acting in that position. And I think on an ongoing basis, the feedback that then came through after, I think it was also of evidence that there were no issues of performance within the function. And obviously there were quite serious issues around various regions to an extent that CEO warranted to act and address those issues. Thank you, Chair.
So you see, you had answers, and
Chair, I want to apologize. I really apologize, honorable members. Yeah.
Okay. Yeah. Who was the last?
I think
You're done.
Yeah, Chair, it's just to confirm two things, and one is that on the issues around the accounting standard, the board has requested 21 days to look at issues around the sorry, Chair. 21 days to do an analysis, an actuarial analysis on the impact that withdrawing from the court would have, and I have granted that 21 days dispensation for them to complete that work. Parallel to that is they want to do an impact assessment and the actuarial quantification on that. And then secondly is to indicate that tomorrow I am scheduled to meet with the Accounting Standards Board in order to ensure that we fast track the completion of an appropriate accounting standard for the RAF. Chair, I want to reiterate the position of the Ministry on this matter. We do not believe that the RAF should be in court on this matter. And we have communicated that clearly and firmly, and we have been met with a response which is simply a no. As I speak, following the SCA judgment, the Road Accident Fund is in the Concourt on this matter. And I want to clarify, Chairperson, that that course of action has been undertaken without the support of the ministry. And that support won't be forthcoming because we believe that this is a matter which, after 3 court judgments, adverse ones at that, should not be proceeding. So I thought I should place that, but for the purposes of progress, I have granted the 21 days following yesterday's meeting, and then we will be in a position to report back to yourselves on the next course of action to be undertaken insofar as that matter is concerned. Thank you.
Maybe when you're still the DM, before I allow other members to come in, was this a board decision to challenge this accounting standard?
My understanding, Chairperson, is that yes, that is the case. My understanding of the latest court action is that it is a decision of the board, but with dissent within the board.
Okay. Colleagues, we are going to take, no, colleagues, you have raised the hands, you are noted. We are going to move as follows. Honorable Van Staden, you will be followed by Honorable Ghana. Honorable Ghana will be followed by Honorable Blosser. Honorable Blosser will be followed by Honorable Montana. Honorable Montana, what is that number? You want to speak again? Yeah, I'll allow follow-ups later on.
Chair, I'm sorry. I omit something which I believe and the ADG reminds me.
Before, let me finalize the speaking list, and then Honorable Montana, Honorable Mkompane, and Honorable Malomaj. You will come in. From there, I'm going to allow general follow-up for everyone, and then I'll take hands for that. Yeah.
I'm sorry. Is to indicate that on the question of the latest decision of the board with dissent, as a result of that decision or its construct, the papers to the Concourt, I'm advised, were signed by the CEO and not the chairperson of the board, who I'm told was not in agreement with the onward proceeding to the Concourt, and therefore the board resolved to delegate the signing of the papers to the CEO. Thank you.
Yeah, I think we've, yeah.
No, Chair, just to get it clear, man, it was supposed to be signed by the chair and the chair refused to sign. May I get it clear then?
I'll ask them to explain it themselves. I want to give the report given to me.
I think let's handle it this way, DM. Honorable Malmat, you're going to have your time. Note it down. You will follow up at that particular time. I think it's a contentious issue that the judiciary duties of the board. I think, Honorable Van Staden, you can shoot. Honorable Malmat.
Thank you, Chairperson.
Thank you.
Just to take note that board members must take note that to mislead the Portfolio Committee of Parliament is a serious offence, and personally, intentionally, provides false or misleading information or statements to a committee can face penalties, including fines and imprisonment. So bear that in mind. Upon your presentation to us tonight, I want to know what is the reason why the Road Accident Fund lost plus minus 25 million rand due to the fact that the fund failed to defend against claims in the court, which results in default judgments. It is also known that the fund often do not send legal teams to court, and therefore the fund do not have legal representation. I want to know what's the reason for this. And on slide 30, you show an amount of last year and this financial year in a total of 3 million rand. Does this not result that public funds goes to waste? Yesterday in the Pretoria High Court, the judge said that the Road Accident Fund made 3 false allegations to the court that this is a serious problem at this stage. I want to know what is the reason for this. And the failure of RAF to carry out its constitutional duties leads to major problems. I want to know, is there a chaotic approach in terms of litigation at RAF? In other words, I also want to know how does your, and want to understand how does your legal department function at this stage? My last question, Chair, will be, what are you going to do about the claims that you did not register but are returning as default judgments? So I want to know, what about those victims' rights and payments being withheld due to your notices? That's it for me, Chair. Thank you.
Ghana?
Thanks, Chair. I wanted the DM to be here. I don't like these long speeches. I don't have the energy for the long speeches. DM, thanks very much. And the board chair, when is the contract of the current CEO expiring? I want an answer. No, I want an answer, please. I only have 3 minutes.
Ghana, let me stop your time. Ghana, through me, please.
Hey, thanks very much.
Yeah, load your questions.
I'm asking for 3 minutes. In the 3 minutes that you will have allocated me, my questions will be asked and answered.
Okay.
Yes.
My problem with that is that if everyone would want to take that approach, we're going to have a dialogue.
It's 3 minutes.
Just ask questions.
No, Chair. I know that I don't want for us to end up in that dialogue that was happening with the acting CEO. I want to flow with my questions. I'm going somewhere. Please allow me. In the same way that you arrived at that interrogation with the CEO, with the acting CEO, because what was being given was not adequate. I'm asking for 3 minutes to have a conversation with RAF and the Deputy Minister.
I don't think we must move in that way, Ghana.
I'm asking.
Declined.
When is the contract of the current CEO expiring? I'm requesting for an answer.
Who's the next question, Ghana?
No, Chair.
It is not going to happen that they'll answer you.
Chair. With the utmost of respect, I believe that what your ruling in this particular matter is not assisting us in holding the board and the executive accountable. The reason I say this, Chair, is because when there were none answers given, you could ask follow-up questions. I don't want to come back. I don't wish to come back. And my questions are related to the first question. And if that first question is not answered, then it means that I will be not asked the questions in the way that I want to ask them.
You are at liberty to ask questions. I'll allow you to come back. Feel free to come back.
How many minutes do I have, Chair?
You have 3 minutes, but you'll have other minutes to come back.
Let me use 10 seconds, and I'll come back for the 2 minute 50 second.
Please.
When is the current contract of the CEO expiring? And whether you have or you intend to advertise for that position. I'll come back and finish my 3 minutes, Chair.
Very much. Next speaker, it's Honorable Montana. No, it's Honorable Blose.
Yes, thank you, Chair. Chair, I don't have much time, and I'm not going to waste my time with the board. Chairperson of the board, did you mislead this committee when you were supposed to come to our virtual meeting last week? Why were you not in our meeting? The deputy minister, you misled him. He gave a report of your absentia in that meeting. And you misled him because what he gave in that meeting was untrue, because someone else said there, the reason you were not in the meeting is because you had a previous board meeting the previous night, which ended very late. But the deputy minister gave us a different story. So why were you not in our meeting last week? That's one. Two, on the day of our meeting, you were working. You signed the special leave rejection, or whatever the thing that you guys were advised of. And you also signed the suspension of the CEO. Again, Deputy Chair, you prepared a report and came to our meeting and told us that the CEO is suspended. And the Chair asked you in that meeting, has the CEO been told that he's suspended, as you are telling us? And when you said yes to us. But you didn't have a signed suspension letter from your chairperson, because our meeting started at 8:30. You didn't have it when you communicated that decision. Again, you lied to us. It is a board that keeps making wrong decisions. You placed the CEO under special leave. You were told by a legal opinion that the decision was wrong. But the legal opinion did not tell you to suspend the CEO. Again, you've taken a wrong decision. And I feel that DM, you are interfering with board decisions, because you ought to leave the board to do its work. And if they take wrong decision, then you charge them with subordination. Because this hoo-ha now that the CEO is charged with insubordination because he did not attend a SCOPA meeting. It was a board decision not to attend a SCOPA meeting. And DM, you interfered with that decision. And the board sitting here, I'm asking you, Chair, do you have a resolution of the board to rescind that decision after the Deputy Minister had instructed you? Which meeting, when did you sit a meeting and rescind a decision that you are not, that now, on the instruction of the Deputy Minister, you are now going to attend SCOP? Because now the bulk is placed on the CEO. Okay. Direct question, Chair. Is the CEO suspended for the SIU report? Yes or no?
Let's move towards.
Chair, I've got 30 seconds. I've got 30 seconds. Okay,
You
Chair.
don't determine your own minutes.
All right, Chair. DM. The board took a resolution to reappoint the CEO, and they did a 360 evaluation on the CEO. That report the board has not finalized. You have instructed them to go and re-advertise for that position. I don't understand. I don't know if DM, you have got the legislation mandate to do that. Is that not interference? Because again, the board is taking a lot of decisions that now are being rescinded. The board took a decision to go and challenge the issue of Discover. They won against that issue. They took a decision to go and challenge the issue of SARS. They got an interdict on that issue. They took a decision to go and challenge AG. And the ministry is coming again and saying that the board must let go of that decision.
Let's move towards conclusion.
So I don't. But Chair, I'm closing.
Finalize, close.
I'm closing, Chair. Acting Chair. Acting Deputy Chair. I mean, my final point, Chair. You've got a tendency of where you lead to create unnecessary chaos. It's the same thing you did at Pick It Up with Amanda Nia. You charged that woman for things that are illegal, and after you've charged her and suspended her, it was found that she did nothing wrong. We see the same trend now happening here at Road Accident Fund, of which we understand that we are at the center of all this chaos.
Thank you, Honorable Closer. Yeah.
Can I not complete, Chair?
We have completed the question. Honorable Montan.
Chair, that's very, thanks very much, Chair. I think as an elder in the committee, Chair, you'll give me more time.
How is this eldership counted?
Well, we'll do it after my 5 minutes, Chair. Let me be quick. Chair, I think, let me start where we ended the last meeting, on the 3rd. We said the board, the entire board should come, and I think that the Honorable Malimeja said, you must tell us, convince us, demonstrate to us why we shouldn't pass a motion of no confidence in the board. That was the conclusion of that discussion. And I think that listening to the discussions, I still don't have the assurance about whether, we are on the right course. And I think that 3 things, Chair, that we should use as measurement. The first one, did the board mislead the committee? That's the first issue. Did the board mislead the ministry? That's the second issue. And these questions are very important in what to do. And I want to pose some questions starting with the Deputy Minister, to the board, and to the acting CEO. Deputy Minister, the issue raised by Honorable Bloss is very important. You, in the last meeting and today, you have made an assertion that everything is wrong. There's quite a lot of, or let me not put it in absolute terms, you actually gave us an impression that there's a big problem at RAF. The chair at that meeting had actually asked but when we were there, when we visited the RAF in October, we were given an impression that this is an organization working in a particular way. The entire board is here. You see, the board can delegate, but it can't abdicate. It also cannot abdicate to the acting CEO. What is within the realm of the board remains there. So if you come to us, if let's say the CEO, acting CEO, or CFO didn't deliver, you can't say it's a CFO. Ultimately, you have to put in place the strategies, the controls, and all of those things. So I think that question about risk becomes very crucial. And I don't think that you should do that. So the issue that we must assess where we misled. Number two, if the DM says there's a problem with the RAF, why is it contrary to the view that was presented to us in our visit? And I think that in what has been going on in social media, we have heard, for example, the speech by the board chair recently with the results. And I think that maybe we should play the speech. You remember at Scopa, stuff were leaked, and the chair spoke about that at great length. Also staff, you've created a culture where staff leak stuff. So they've leaked to us, and if you listen to in the results of the result, I could play it. It's in my own thing here, where the chair said we are doing so well. This is such a grave contrast between what the deputy minister is saying, okay, and what we're getting an impression. So it's either the deputy minister has done an assessment of the performance of the RAF that is objective, we can look at indicators, or we can conclude that the board misled the ministry in terms of its own performance. And I think that is very important. That's a very important issue for me.
Yeah, let's wrap up.
I'm about to wrap up,
Yeah.
Chair. So, Chair, I also want to check. You asked a question at the meeting to the deputy chair whether as we were discussing on that day, the letter of suspension had been given to the CEO, and I think that we got a confirmation. I just want, in the light of this one about the CIO, is very important. And the acting CEO, I think that perhaps you need to indicate to us when exactly did you get all these instructions. You signed yesterday. I just want to have a sense about all of these things. And Chair, my last shot is in the light of what the Deputy Minister said about the board and the resolution on the standard issue. I just want to hear, because he said is the chair of the board. We've got members of the board here. They haven't spoken. We don't know what their thinking is on this issue. Because I think that for me, I want, when I stand here, to have the assurance that we've got a board that is really managing this entity. But as I see it right now, I'm actually worried that we are not getting that. And I think that what we wanted to propose to the Deputy Minister and therefore to the ministry,
thank you,
that we pass a motion of no confidence in the board.
Thank you.
Because that's what we need. That's what we spoke. But
Thank you,
we need to see
Honorable.
the answers.
Thank you, Honorable
Thank you, Chair. I
Montana.
thought
Thank
I'm
you.
still the elder, but I realize I've been demoted, Chair. Thank you.
Ngomban, Honorable Ngomban.
Thank you, Honorable Chair. Chair, let me appreciate the report and also the honest and progressive comments by the Deputy Minister when doing his opening remarks and also indicating that there are difficulties at RAF. And the situation currently is not good. And also, in the same vein, I would like to appreciate the powers given to the committee by the rules, as that has been mentioned by the chairperson of the board. Quickly, Chair, my questions. I thought perhaps I would be given the reasons, because they outlined the SIU investigation, timelines, process followed, then reasons and policy provisions. But I couldn't hear the reasons, if we may be appraised on that. I leave the budgeted post, Chair, and the vacancies of the chief positions, the 3 chief positions. I think we need more here to say when perhaps will these positions be filled, because the chief claims officer, the chief corporate support officer, and chief investment officers are very key for the entity to function. Chair, on outstanding personal claims and direct claims versus legally represented claims, there was a say that from the acting CEO, to lodge a claim, one has to be a lawyer. What does that mean when a person is lodging a claim when he or she is not a lawyer, a direct claim? What does that mean? Then, Chair, in 2015 to 2020, the target was 1,440 days. In 2025-26 is 120 days target. Then there is a silent period of 2021 and 2024. What was the target? Those financial years. Then lastly, Chair, yes, on the second slide before the last one, that is slide number 37, there's something there that has been written, CEO post advert. But below, it doesn't talk about the advert of the CEO post. What is the meaning of that heading? Thank you, Chair. Oh, the last one, let us request, Chair, to be supplied with the owners of the leased buildings, all of them, not only the Johannesburg ones. We are interested to know who are the owners of the buildings in Durban, in East London, Johannesburg, and all those areas listed there. Thank you, Chair.
Thanks very much. Honorable Malmaja.
No, thank you, Chair. Let me also follow suit and welcome this really embarrassing kind of presentation. One, in your own presentation, you said for a period of 10 years, you have spent plus minus 854 million for release. The question will be, at what point do you realize this was wrong? And why now, and why you want to give it to the CEO as if he's the only one? Then if you realized earlier on, why should we still keep you if you cannot save such funds? Still on that, you talk to us, how far are you with the court order where RAF has to pay 1.4 million to a Malawian? And how many of these foreigners are really getting this money when the South Africans are still queuing? Because your own selves is like you're not sure in terms of the papers. Chair, the earlier incident demonstrated very clearly, without any doubt, that this board that we're facing today is not assisting, and it will never assist. You have an acting CEO who is very fast to take us through, but when coming to responsibilities that can put him where he's supposed to be, he can't sign. You have got the acting chair who is time and again lying to us, and who is very agitated when we deal with the matters. If she wants me to prove that, on the 3rd of June, when we had a meeting, we asked her for about and halfway of finishing the meeting. It's only then she said, then the chairperson has got the family issues that she cannot make it to the meeting. And I want to tell and put it to chairperson that you have deliberately decided not to come to that meeting. That is why your apology was to be manufactured in a way that today we are here, and I'm still saying, why should we keep you? The very same reason that the Letswalo CEO was suspended because he did not attend other meetings. Why can't apply that to you? DM. In many cases, it's unfortunately but I will have to do this. A parent who's overprotecting ends up in trouble. When we were here, we are trying to get exactly what is happening in RAF, where you too, you also accept that there are problems. You want to profile yourself as if you can defend everything. We are telling you, in front of you, they've embarrassed you, these people. You had to stop, you have to come in, you have to seek and dig for the truth. And it's not what we're expecting you to do. We're expecting you to crack the whip. And when they come here, they must be honest with us. We're not here to play. These people are getting money of the CEO. He must tell us everything that we're supposed to do. Actually, it's not by favor. Portfolio committee, everyone who touches anything that has to do with transport is accountable to us. Yourself, the minister, and this board. And if we are not happy with this board, we must tell you that we are not satisfied. We want them here. If we are to put so that the public can know why we invited Mr. Letswalo, it's exactly what the earlier incident by the CEO prevailed, where we could not get exactly the sense of what is happening. Chair, when it suits you, the law applies. Yeah? When it suits you, the law applies. We are telling you that by the time Mr. Letswalo was sent home and other things, some other papers were not signed. Here again, you are attesting to us that you suspend the CIO without even having a written letter on that.
As you conclude, Honorable Malman.
And I agree, Chair, when I learned this board, that question hasn't been asked. Do you see yourself still relevant, can be kept by us? Give us the reason why we must not dissolve you. Thank you, Chair.
Thank you, Honorable Malman. Yeah, I think I've captured everyone. You lead the pack once again.
Chairperson, thank you very much. At the very outset of this meeting, I indicated that yesterday I had a full-day meeting with the board. I'm compiling a report with the ADG and I'm considering my options. But there's information and issues which are still outstanding. The second point, Chair, I'm not sure of this very grandiose characterization that I'm interfering. The decision of the board to place the CEO on special leave was a decision of the board which they communicated to us. Honorable Blosse is a member of SCOPA, and he would know how I reported that matter. One thing, Chairperson, I'm very clear about is the fundamental difference between interference and interface, and the absolute responsibility that we have to ensure that there's due compliance. It is not interference to tell a board to come to Parliament for it to account to Parliament. What was I supposed to do? Smile and wave and kiss babies? When a board of an entity within my purview takes a wrong decision, which I've repeatedly said that it was wrong, to go to a meeting which he, Honorable Blosse, is a member of. That's the second point. Thirdly, I have a responsibility to ensure stability in entities. The contract of the CEO ends on the 6th of August, 2025. Recruitment processes take a long time. I'm saddled with another entity where we have not been able to appoint a CEO. And that has given me the experience of why it is necessary to make sure that things are done on good time. I requested a full and comprehensive list of the expirations of the CEOs and the boards within the purview of delegations which we have presented to this committee. Now, the minister has to appoint a CEO on the basis of a recommendation from the committee. All of us here who are public reps are elected on a 5-year term. And we go and subject ourselves to the biggest panel there is in this country, the electorate, when that term of office expires, for it to make a determination of what it does with us. Somebody who applied or wanted to apply 5 years ago and did not meet the requirements and meet them now has got a legitimate expectation that when a contract ends, they will be considered if they apply and meet the minimum requirements. Ukhuluma ngo 360 and evaluations If he has that report, good for him. I don't have it.
Okay.
What I have asked the board
Chair.
to do.
What is that, Honorable Bloss?
Chair, I asked a question in that. So the DM must not say it's my report. When I made that articulation, I asked the question to the board. Do they have a resolution to reappoint, and have they done a 360 evaluation on the CEO? It's the question the board must tell us.
No,
so the DM must not pack it back to me. I put it to the board. I need a response from them.
Honorable Bloss.
So it's not my. It's a question I asked.
Honorable Bloss, thanks for the intervention. It's fine. You don't have to be emotive on it. Yeah, that's the context, Honorable DM. This question is not.
Nonetheless, Chairperson, it's two sides of the same coin. He says that I'm interfering. I'm interfering when I'm asking the board to follow due process, when I'm not implementing the due process. I'm saying to you, Chairperson, if the CEO, whom has a contractual relationship with the entity and his term of office expires and has a wish to continue as the CEO, he must go through the process like everyone else. How is that interference? I say this, Chairperson, because over the weekend there was some tweet about all sorts of manner of things coming from members of parliament. It's saying we have taken decisions that we have not. You see, Chair, what is going to collapse this oversight responsibilities is an outlook to want to be a player and a referee. My only expectation is for the board to ensure, already now we are in June, we have to now ask ourselves the questions, what happens on the 6th of August, right? And that's why I say there's a responsibility for stability. And I stand by the outlook that we need to advertise because the term of office will expire. It's a contractual obligation, relationship. I mean, unless there is some magic wand that can be waved outside the act. But what I need to do, because by the way, Chair, maybe for clarity, all submissions in the Department of Transport on any matter come via the departmental structures that ADG and myself and go to Minister. I must be in a position to advise the Minister correctly, and I intend on doing so. When I receive a report from the board on the due processes that have been followed for the purposes of filling the vacancy of the CEO of RAF. As we are seated now, we are currently in the process of advertising, as the advert is already out, for the board of the RTMC, so that we've got a lead time, so when it expires, we are able to fill the vacancy. We have gone on far too long in government, in my own assessment, where we leave things to the last minute. It will not happen under my watch. So if that is interference, then charge me. Charge me.
DM.
Yeah. Then, Chair.
DM, that part, we don't charge. We don't. So you are daring us to charge you now. Don't go that direction. Just continue to provide answers.
Then, Chair, is the issue around...
Just DM, Honorable Mutan.
Chair, can we clarify so that the DM deals with this thing properly, in the proper context? The question is, in filling the position of a CEO of an entity.
Speak to the mic.
Sorry, in filling the position of a CEO of an entity. Is that the responsibility of the board, or is that the responsibility of the department? The board comes to a determination. It recommends for cabinet concurrence. So I think that it is in that context that Bloss is raising this issue, DM, not all the other issues that we are addressing.
Covered. I think the point is covered.
Let me start.
Do you still want to say something on it?
Yes, because
Okay.
there's a no, Chair. I asked for a schedule of boards and CEOs. The lead time of the due processes is long. I asked the board to begin the processes of the filling of the vacancy so that when we come to the 6th of August, we have gone through all the processes. We are not to start on the 6th. That's point number one. Secondly, the board will recommend to the minister, and I will ensure that the minister receives that recommendation, and we will take it to cabinet for the minister to appoint. It's the minister who appoints. And all I'm saying is the minister delegated entities to myself, including RAF, in the assist of the exercise of her responsibilities. And I am indicating here that where vacancies are bound to arise, we are to fill those vacancies. It's as simple as that. And what I'm saying is that it must happen because there is a contract of 5 years. I have not said I'm going to advertise. I've not said I'm going to interview. All I've said is do what you must so that we can be in a position to fill the vacancy when the time arises. It's elementary, Chair, it's common cause, it will happen. And I'm saying, Chair, in the SCOPA meeting where this matter arose, it was raised in that meeting, the latest developments insofar as the substantive CEO is concerned, who is now on suspension, are quite apart from that. They are recent. My correspondence in Dala on this matter. So the two are not related. And I indicated, and that's why I kept on emphasizing that in my view, the special leave is without prejudice. But it must go through a process.
I think that
Then
point
lastly,
is
Chair,
substantively covered now.
Lastly, Chair, I'm accused of interference insofar as the board decision is concerned about coming to Parliament. No, I don't think so. I think I was doing and will continue to do what I believe is right, that when called upon to do so, we must appear before Parliament. You will know that yesterday I brought to your attention that we have this legal conundrum of the matter being in court. But we are here today with the board. There was no, overtures to say, can we postpone and so on, and ultimately we came to the decision that we must appear before Parliament. Is that interference? Because I think, Chair, what I will not accept is characterizations which are baseless, which seek to cast aspersions on myself. We go to the issue that is being raised about SARS and court. When I was briefed by the board chairperson, after they wrote to me that there's a 5.1 billion rands matter, and the intergovernmental mediation was to proceed, and the board said that they're going to court, we gave them the support and the green light to do so. So, is that interference? I think what we need to distinguish, Chair, is that the issue of the accounting standard is ultimately wrong. It's completely and utterly wrong. Because what will happen next, we're going to be called here, and it will be the very same committee that says, on your watch. You see? Now, let me then say this.
Yeah, wrap it up there. Honorable Montana, I'm not sure you still want to make that intervention, really.
Is to say, Chair.
Please, Chair, so that when the Deputy Minister, because I think, I don't want us to speak past each other, Chair. Let's clarify this issue again, DM.
Maybe hold it there, DM. Yeah?
Can we clarify this issue, Chair? Because DM knows that even at the personal, professional level, we've got huge respect for him. Let's deal with the issue. When the DM says this issue of the standard don't go to court is wrong, okay? What's supposed to happen? And he said himself that he's still going to meet the board that determines the standards. The board must do the work. You see, what he can ask is that the board should stay.
Honorable Montana, hold it there. I think you are revisiting the question. What we will do, we're going to allow you a last roundup because otherwise we're not going to finish. We're going to be intervening on each and every matter. He's captured now. I think he's going to respond to it now, and then we as you wrap up on these matters involving you, DM.
Yeah, no, Chair. We've traversed a very long journey on this issue of the accounting standard, and as I've indicated here, is that the board has asked for 21 days. It's as I've indicated to you that the board, there was dissent to the extent to which the court papers, I'm advised, ended up being signed by the CEO to go to the Concord. So, and the position holds to say the AG has made a determination. The ASB informed Parliament. You can pull out the records. Informed this institution, the Office of the Accountant General, National Treasury, the previous scoper, on the basis of outlook on the issues. Now, what has ultimately happened is that the board has arrived at a determination to say they want 21 days, and we've granted that 21 days in an outlook to say how do we, in a responsible manner, facilitate the withdrawal of the court action and apply the standard as it is now, at the same time find an appropriate standard. But above and beyond, it goes to the issue I've raised before. We are in the process of a legislative review, and we are en route to bring a bill to Parliament on the issues of the road accident fund, so that. Now, lastly, Chairperson, what Honorable Malmacha says is absolutely correct. My interventions do not seek really to protect RAF, but what I'm trying to get at is for RAF to subject itself holistically to oversight and accountability to Parliament in order to enable Parliament and ourselves to take the correct decisions. And that is the start and end of it, Chairperson. And we will come back to the House on a roadmap that we will develop. What you must know, Chair, yesterday I had a very, very extensive meeting with the board and the executives. Very extensive. I am still seated here, settled with the fact that there are whistleblower reports which have come my way, which have come the way of Scopa, which completely and utterly change the outlook about their issues and affairs at the RAF, of which now I am trying to have them tested correctly so that we can apply the applicable remedies to it. Issues around corruption, maladministration, misrepresentation of facts and information submitted to Parliament. But what I won't do, Chairperson, is take hurried decisions without having undergone due process. So when I say, Honourable Montana, that all is not well, I say it because what has transpired extensively and exhaustively in the last few months, and specifically weeks, is a concerning situation. And it also, Chairperson, precisely why we believe the legislative reforms are necessary. Because the flip side of the coin is that beneficiaries and claimants are struggling with the lawyers. They are absolutely struggling. We are saddled with high bills of foreign nationals in the country, which come in and then get money. And so every single day, Chair, our phones are being blown up by complaints. We have instituted a process with the Deputy Minister of Justice to intervene on the judicial matters of the processing of claims, as the report says specifically in the Gauteng division. Amongst others, because of those concerns. So when I say that the situation is bad, is because we need to look at the entire ecosystem, which is inclusive of the audit outcomes, the performance indicators, the operations and information that we have at our disposal. Thank you.
You can pass the bite.
Chairperson, you will delegate to the board and the executives as you deem fit.
Thank you, DM. Honorable Chair, let me start with the matter of the meeting of the 3rd of June. When the invite from PCOT came, I already had a personal commitment to take care of a terminally ill. I'm sorry to say that now I have to, I did say personal matter of a terminally ill family member who have since passed and will be put to rest this weekend. And I couldn't walk away from that. The first thing I did when I received that, I wrote a note to all the board members. I think the board secretary will communicate that. And I said to them that the deputy chair will attend because I have a personal commitment that I can't cancel, that needed me to be available at the time. I couldn't walk away from that as a woman in my age and responsible, because some women, I don't know whether I have to go through that, but there is evidence. The board secretary will give you. The only mistake that happened was that he omitted to write a letter of apology, which should have followed, because there is the administrative aspect that the board and secretary does in terms of communicating with the various structures. And I even sent a note to the deputy minister as well, informing him that I'm unable to attend. That WhatsApp is still available as well. So you will get those documentation to say that I couldn't walk away from that. And that's why I delegated correctly. It's not like I did not want to come. Okay, sorry, can I just finish? And then...
on that, Chair, because I don't want the Chair to move away from that.
No, I'm not moving away from that. Sorry.
Just hold, Chair. Honorable Bloss.
Yeah, but she must not do that as well.
Oh,
Chair,
sorry.
No,
in the meeting,
address me.
In the meeting, Chair,
yeah,
the DM gave that explanation that she's giving now. And the question was that the Secretariat has not sent us the apology. And then there was a person who was in the meeting with an something device. That person must reveal themselves here. Who gave a different explanation as to why that thing is on record. They said that last night we had a board meeting that ended very late, and because of that, that's why the chairperson is not here. It's on the record. So they must confirm to us here, because that's what I'm disputing.
Yeah, it's noted. I think they'll come to that. You'll have to deal with that. Yeah.
Yeah, Chair, what I try to explain is that maybe two contexts. The chairperson of the board is right. In two instances, when the special meetings of the board were held, she actually communicated. That will actually be provided for in the minutes. So what I was simply saying is that is in terms of my liaison with the secretariat of the PCOT. So what I was simply saying is that because the meeting of the board ended around 11 o'clock, I could not get hold of the secretariat of the PCOT actually to communicate the apology. But I said to the members to say that in future that particular deficiency will be addressed. And we've actually addressed that because Chairperson, already a day before yesterday, we communicated two apologies to the secretariat of the PCOT. And I apologize for the late communication of the Chairperson's apology, Chairperson. That is the matter for the record. So, is something it was the board secretariat of the RAF. Thank you very much, Chairperson.
Okay. You are fine now, isn't it? Yeah. Chair, you can get out of that one. I think it's clear now.
Thank you, Honorable Chair. And Chair, the second matter regarding a possible lie, the fact that I stated that the RAF is performing very well, that is on record and audited. From 2019-2020, the RAF recorded 57% in performance of its APP targets. Last year, we recorded 84%. No, the year before that, which was audited. And then this current year, the 2024-25, it's sitting at 85%. That is the unaudited performance results. From the time the 5-year strategy started, all the performance record of the APP have been audited by the Auditor General. So those numbers are factual and correct. The only year that is currently undergoing audits is the current year, which is sitting at 85%. But all our performance, our APP performance record have never been qualified by the Auditor General. So that is a matter of fact. There's a difference between performance and misconduct. Most of the issues that we're dealing with now relate to matters of misconduct. But a person can perform, and then there could be areas of lapses in conduct. So I think those are two different things. So that wasn't a lie, it's a fact. You'll see the unaudited APP performance is sitting at 85%. And it's also on record that this board actually put almost 50 billion in the claimants' pockets in the last 5 years. That has never happened before in terms of bringing in efficiencies in the processes. We've taken a lot of money out of administrators and put it in the hands, in the pockets of the claimants, who are basically our core in this organization. That has also been shared over the years in terms of progressively the savings and the claims payments numbers, over the 5 years. So again, that is undisputed numbers that in terms of the performance of the organization. Yes, we've accepted as a board that there's a lot of challenges still existing in terms of, dealing with certain matters of in the RAF. We accept that, and there are, we basically looking at it with open mind and also putting in new strategies to deal with those things. And matters that we can fix immediately, we're doing that. I mean, with the current positions, we did say to the acting CEO, please, we gave him 4 months to fill the critical executive positions. Then we said the vacancies, fill them temporarily with experienced people so that there is no gap. We're not looking for, challenges now that, you have people acting, but they don't have the competence and the experience to do that. And he has, even including the head of legal. The head of legal was there. It's just that the person was not given a proper acting appointment. But she has been working in that environment. So we've been very clear. Even the matter of the acting CIO, when the matter came to us as a board, we commissioned the REMCO subcommittee to go and do a preliminary review on that. And they came back and confirmed matters of misrepresentation, non-disclosure of critical interests that really confirm integrity issues. And there's additional, substantive matters that came out of that. That's why the board, after following, also getting legal advice on that one, took that decision to place him on suspension. So low-hanging matters that the board could actually deal with, we have been decisive in terms of dealing with those. Thank you, Chair. I think the CEO will deal with the operational matters. Thank you.
Yeah, thanks, Chair.
No, Chair, I just need clarity. Who's going to deal with my question of the reappointment and evaluation of the 360? I'm asking because now it's passing to the CEO, so who's going to deal with that? Because that's a board resolution. I specifically asked about it.
You would have realized I've not even agreed that you must speak. And I don't think that's fair for the meeting, because if you were to do a follow-up, you would still do follow-up on that question. I don't think now you are being fair to the meeting, Honorable Blose. But perhaps if you could quickly deal with that, Chair, so that you can pass the bite when we've exhausted that.
Honorable Chair, I did state that I can't answer questions that affects the current case. But what I can say is that once the court papers are out, probably by the end of this weekend, some of the answers will come through. I mean, members will be able to read those court papers. But I can't.
Thank you. Yeah.
Thank you.
So you answered on that part. The matter is sub judice. See you.
Yeah, thanks, Chair. I think the first question I think specific question was from Honorable Montana around the timeline around the CIO. I think I'm not going to make the mistake and detail that. From the instruction of the letter that communicating that the board had resolved to put the CIO, acting CIO, on suspension, was sent to me on the 3rd of June. It landed around 8 o'clock in the evening. Obviously, that was after the meeting, the portfolio committee meeting on the 2nd of June. I did
repeat that.
I'm saying the letter to suspend the acting CIO was submitted to myself on the 3rd of June, 8 o'clock in the evening.
Not in the morning.
Evening. I then replied the following morning, registering my reservations. That if I was to execute this in my capacity as the acting CIO, I have a responsibility to, at the very least, consider what the board would have considered in arriving at that decision. Subsequent to that, obviously, I was warned about the possible delay of executing this decision because the board had made the decision. But I was never going to be a rubber stamp to that decision. That was my position, and it is for that reason that I decided to apply my mind to the matters until I received the file, did my own assessment with the internal ER within the organization, and as I indicated that in the circumstance, I will be a charging manager who must appear before the CCMA when the matter unfolds. So I think that's the position. And if obviously that assertion is considered insubordination, I'm prepared to face that particular charge, because I don't think I'll do it any differently. If it happened in the circumstance. I made the point that when the announcement was made, when the presentation was made to PICOT, we received it and we received the announcement together. This acting CIO was sitting with us in the boardroom. So it can't be correct that to expect that then you must then consequently just sign the letter, and therefore, if you don't sign, then it becomes a problem. So I think I just thought I should address that. But in terms of the others issues, I think there were just two other operational issues. I think that were raised around the specific targets, and whether or not the 120 days target, when did we start implementing it. I think we started implementing the 120 days with the strategy 2020-2025. I think the 1,400 target I referred to was in the previous strategic plan of 2015 to 2020. I think that's the main issue there.
I've seen your hand. You'll come in.
Yeah, you can come in.
You'll come in later on. Yeah. Maybe before you leave the platform, just for the purpose of record, as acting CEO, do you sit in the board?
Yeah, all these meetings that have been referred to were special board meetings, in camera board meetings. So ordinarily we sit in open board meetings, but not in camera meetings that we're discussing, amongst others, the issues around the CEO appointment or suspension.
Okay, sure. If you can come in.
Yeah, Chair, with respect, I wish just to place on, I wish just to place on record, Chairperson, there seems to be a confusion. If you go to Hansard or check the presentation that was made by the Vice Chairperson, this is the Vice Chairperson said that the board recommended, not resolve. Because the understanding of the board at the time is that in terms of delegated powers, the decision to actually implement lies squarely with the chief executive officer. So, but I just want to put on record, Chairperson, to say at the time it was.
You must assist us, Secretary.
Yes, Chairperson. Yes, Chairperson.
We are very normal. We know what the chair said, and she did not dispute what she said. She said the CIO is suspended. Yeah, and she confirmed that. Yeah, I don't know what you are trying to do now, Honorable Ghana.
So I will have asked, Chair, in my line of questioning, when did the acting CEO get appointed? Which meeting appointed the acting CEO?
Chair, if I just in the chair is just walking in, we appointed the acting CEO on the meeting of the 27th of March. No, sorry, not March, May. Sorry, May, 27th of May.
No, it's fine. Let them finalize. I think I understand why you are all raising and I understand why you wanted to throw questions directly now, because it's now even more confusing.
The manner in these things are sequential, and if I speak for 3 minutes, then there's no sequence. Because what you will start realizing, Chair, because now I'll ask the CEO, I don't know who answers this question, to say, in the EXCO now, at the time of appointment, how many people will have qualified to have been a CEO, considering the number of acting positions at the EXCO level? And at the moment, how many at the EXCO level of RAF are actually not acting in their positions? And you'll find that there are like 2 or 3. You have an EXCO that's acting. Now, if Chair, where I was going to go to, in that response around the board, the delay in the acting, what do you call, implementing of the decision. Let's say the board decides that the acting CEO has its insubordination. You use those words. Then you start to realize that you are running out of people to act in acting positions. That's where you are getting to. Because like if you look there, it's all actors.
Okay.
And Chair, as a last, maybe to end with this, there's this marketing contracts, as it was revealed to Scopa, 2 of them worth 500 million. You know them. You gave Scopa that. Who will have been the person that signed those contracts in this whole acting? Because I don't know who's acting where now. Who is the person responsible for signing these marketing contracts and advertising contracts at RAF at the moment?
Yeah.
And what's the level of vetting? So as a last, when someone is appointed to an acting position, what level of vetting is done? Because that acting CIO, it's clear that there was no vetting. And these acting positions are used to say, no, you can come act, there's no vetting. We'll only vet you when you are appointed full-time. As a result, you've got positions that remains vacant and there are people acting for a long time because there's no vetting for actors.
You were following up. Let's leave it there. Let them answer. I've seen your hand, Honorable Mabena. Then you can then follow up. You were passing the bite, but there are supplementary questions that were relating to that. I'm not sure whether they are going to the board or they are going to yourself. I can't see you there, but I saw you wanted to intervene on some answer.
Yes, Chair. Thank you. Good evening, members. Chair, I just wanted to answer on the issue of the foreign claimant. That is a Malawian claimant that's claiming the 1.4 million. That's Modao case, and we've appealed it at the SCA. That's part of our issues to say that we need legislative reforms in terms of payments of undocumented foreigners that we're busy with. So it's at the SCA. Secondly, Chair, I just wanted, because the issue around who signed the papers to the Concord with regard to the AGSA matter, that there was a dissenting voice in the board meeting. I would just like the COSEC, as the keeper of secret and knowing what really happened at the meeting that we are all in, to that just make it clear to the members here what had happened at that, because there was no dissenting vote there in that meeting. So the COSEC to please just clarify it in terms of governance-wise. Thank you.
You're part of the board.
We were in that board meeting as executives and the board deciding on what's the next step in terms of are we going forward with the AGS matter or not? So I'm not part of the board, but the executives are invited to board meetings. So we were there when the board made a decision on this matter.
DM, but do you see what we are now subjected to?
Chair, let me, you see, Chair, yesterday, amongst others, this is precisely, maybe let me be this candid so that I don't have to come back again. We are settled, Chair, at RAF with the following: a divided board.
Okay.
We are settled with sharp differences on issues, and we are settled with the board and executives whom no longer, in my opinion, work well together. If I were to use a political term, I would say factions
in the
board are about in RAF as an ecosystem, board and executives. I used the term earlier on, uktibelan, and how I put it in English. And this was very clear yesterday. That is, and this is why I keep probing as I do. So that it's clear what you see. Let me, the Scopa meeting was a similar scenario. It's accusation and counter accusation. So that's the bottom line. And I don't think it needs to be said because it's categorically seen.
No, it's fine. So I just wanted that intervention.
Let me then say this, Chair, on this issue. The Secretariat and the board can take you through the sequence of the issues around the Concord. But yesterday, yesterday, the issue of the papers was put to me by the board and the executives that the chair didn't sign. and she indicated that she didn't agree that we should continue. Manje, if that's not dissent, then what is it? This is ultimately.
So you are equally picking here with us now that there was no dissent. Is
I'm
what you're
saying to you, Chair, yesterday, I was informed. So what I'm saying to you, Chair, is that the Chair was not in agreement, anti-including what they're reporting. And therefore the board delegated that the CEO should sign.
Okay.
And if Bepiga, Chair,
DM,
it will tell me everything I need to know about yesterday.
Yeah, no, it's fine. Madam at the back.
Thank you, Chair. I think the Chair can clarify this. Yesterday in the meeting, she said the board voted in favor of continuing to the Concord. And in that meeting, there was no dissenting vote. Subsequent to the meeting, she had her doubts, and then she decided not to sign the papers. So in the vote to go to the Concord, she did not have a dissenting vote.
Thanks very much.
May I request just one thing?
Yeah.
She's here.
Look, you know, you were subjected to this and that counter say. Now you will then appreciate why we needed to have this type of a conversation. Imagine the embarrassment we'll suffer if we were to meet with Scopa, having to do oversight on this committee, appearing in Scopa, meeting this type of understanding for the first time. Ndateltwal, you are not a participant on this one. Your time is coming. You still gonna, I see you are busy raising your hand, Ndateltwal. We're gonna come. We're going to give you an opportunity. We're going to ask you questions. Honorable Bloss, I'm ruling on this matter. Colleagues, I don't think I'm going to allow follow-ups on this matter. Yeah, but I don't think it will assist because you can see what we are dealing with. And this is in front of the people of South Africa, by the way, we're live. Now, DM, I think we might need more conversation about this spot. And I don't think continuing to ask them questions is going to assist anyone. Because I condemned that, or I called him to order when he was saying they are misleading. But it would seem that they were misled back and forth. And I don't think that's the direction we need to take. I think perhaps in as far as answering from the board, we must leave it here now. And then, but let me not suppress Mabena. You had a question, Mabena. My fear is you will still be taken forth. Someone will answer and someone will counter. But let me allow you that opportunity because I have suppressed you way too.
Hey, Chair, I don't know, like, we are very different today, like, we are definitely, I don't know, maybe I must change the soap that I bath with. Eh? It's different, like, honestly. You
are suppressing me.
I think, yeah. But here is the question. On the issue of vetting again, someone that is acting is not vetted. And then we said also that there is ongoing vetting that is currently happening. Here is my question. If the current vetting process comes back, says A, B, C, D have failed the vetting or their vetting was not successful and they've been acting, they've been exposed to state secrets without a security clearance, who ultimately must take responsibility in terms of that? Because that means you would have exposed the most sensitive information to someone that was not vetted. And the thing that we are saying that there is a vetting that is currently ongoing. And I believe that the vetting also is quite extensive to other executives. So now, all of those people, and we've got so many acting chief executives at the C-suite level, and all of those comes back and says none of these people, I'm not preempting the process, but I'm saying as a risk mitigation strategy at a board level, we spoke about here that there's a regal that is there at board level. What then do we do at that level? Because someone that was acting would not, you might not be necessarily be in a position to even hold them accountable if it comes back to say that they failed the vetting process.
Thanks, Honorable Maben. Honorable Kwabe, do you still want to really say something?
Chair, it's just a clarity-seeking question. I think the deputy chairperson said that the acting CEO was appointed on the 27th of May, but Mr. Letswalo was then put on special leave on the 28th of May. So during that 24 hours, did RAF then have two CEOs? One acting, one new acting, while Mr. Letswalo was there until he was then given a letter or the instruction that he's on special leave. I think maybe I'm confusing the sequence of events, but if the board could then clarify us. Thanks, Chair.
Chair, if you could come in on these two questions that have been asked. I'm closing it now. Because I think we are becoming a circus now. We are becoming a circus. Please, comrades, colleagues, please, just allow me to lead you now. Just allow me to lead you. Can I just really subordinate you to my chairmanship, please? If you can come in, I've seen you have been agitated from a long time ago. You're raising your hand. I'll only allow you and allow the chair, and I'll close on you guys. And perhaps I'll even release you.
Yeah, thank you, Chair, and thanks for the opportunity, I guess, to allow me to speak. I think before I speak, one has to confirm that sometimes it's quite hard and difficult in some of the circumstances. But Chair, I want to be transparent and share a couple of things. I think of recently from audit committee, and I'll bring the issues of risk governance into play. Of recently, I can confirm that we have signed off the F's, the annual financial statement for AGSA to audit. We've also signed off the APPs or the APR for same for the AGSA to audit. There is assurance as well that the internal audit has audited those numbers, and we're comfortable with that. We're now waiting for AGSA to then pronounce in that regard. What that demonstrates is that from a performance point of view, just in terms of the APP, the organization has achieved 85%. When you look at the same number over the last 5 years or so, on average, the organization has achieved 84%.
Without disrupting you, my man, go straight to your point, because that matter has been clarified properly. That you,
the point I'm trying to make, Chair, is that as a chair of audit committee and on behalf of the audit committee, I think we have also picked up issues around governance failures within the organization, to the extent that in terms of Treasury Regulation 3.1.1.15, we have actually returned to the ministry around the concerns, because that Treasury regulations allowed us. This is now the audit committee. I just wanted to be transparent and put it before the committee that...
What are the issues you are raising there?
Chair, the letter has been submitted. It has been acknowledged. I don't want to disrespect the ministry. In there, PCOT has been cited. I would respect that you get that letter at that point in time, if the chair allows. But there are
PCOT is cited. You are saying the PCOT is cited in the letter?
Yeah, the PCOT was cited, or an issue that impacted PCOT is highlighted in there.
No. Hi. DM, do you have this letter that the audit is speaking about?
Chair, the letter, I learned about the letter yesterday, Chair. And secondly, Chair, let me say this. I want to indicate this, Chair, when I speak about the ecosystem, and make an example and say the Department of Safety and Security here in the Western Cape gets a clean audit. But if you look at the elements and areas of crime within the Western Cape, you see the challenge that we have. And so the context in which we say we're looking at the whole ecosystem is inclusive but not limited to impact of what those audit outcomes and assessments do. Now, what you're going to have yourself settled with here, Chair, as an observation, there is a tendency at RAF for everybody to try and prove themselves right and everybody else wrong. And then it becomes a... And so I'm asking you, Chair, to beg your indulgence on this matter of Concord, to ask the Chair to respond. Maybe put it differently, why didn't she sign the papers?
Look, I've already requested the Chair to come in. I think there are 3 issues that she must come in on. There are follow-up questions by both Honorable Ghana and Honorable Mabena, and the very issue that has been claims and counterclaim. Kubeka, can I just suppress you and I close it at that? I think we must release this board now. After the response by the Chair, I'll give you direction on what must happen. Let's you'll have to come closer when we are done with the board. Members have some few questions to you, directly to you, that we may want you to clarify. Yeah. Not now. Let them respond, and then we'll take a decision on how we move forward with them. Yeah. Chair?
Thank you very much, Chair. Regarding the matter of the AGSA, okay, let me just explain the decision-making process. The decisions of the board are taken by consensus, majority consensus. And then afterwards, there would be board members who dissent and placed on record or disagree. But also the process allows for a member to, if there were issues that were raised unresolved in the process, they can, subsequent to the discussion before the implementation of the decision, express, because we professionals, they are allowed to express their disagreements if they're material. So regarding this matter, the decision of the board, the consensus was reached in the meeting regarding this matter. But there were questions that I raised that were not answered in the meeting. So I decided not to disrupt the decision-making process because obviously the consensus was reached. But subsequent to that, I wrote a very detailed letter stating that I'm in disagreement with the decision because there's certain fundamental questions that were not answered. So the board called a special meeting, and in fact, before the signing of the Concord papers, I made sure I actually requested a sitting to go through those unanswered questions so that they can satisfy me as a chair of the board, because I had a fiduciary duty to sign this, and I couldn't sign in principle if there were fundamental disagreements and unanswered questions that would be a deal breaker in terms of my fiduciary duty as a board member, and secondly, as a chairperson. Can I finish? And after that, they went through. Can I just explain, Chair?
No. Honorable Kobe,
So the meeting was taken. There was a special meeting to consider my concerns. But instead of considering my concerns, the meeting turned into taking a decision to appoint the CEO to sign, because clearly I couldn't sign. I did make it clear to the board members that if my questions are answered, I won't be able to sign because I'm not comfortable with the decision. So that's what happened, Chair. Then I didn't sign.
There was a question relating to vetting, to vet act member. That was the question, Honorable Ghana, right?
Okay.
Yes, it was. So I'm saying there seems to have been, and this continues, that people are appointed in acting positions. Because if they are acting, then there's no need for vetting, because you're appointed today. I guess on the 27th, when you're at the board, the acting CEO didn't know that it's going to be the acting CEO. In the evening, it was the acting CEO. So there are no checks and balances. That's why you are sitting with the case of the acting CIO that you had to suspend from an acting capacity, because was just taken in like appointed. I know, come, China, come, you're appointed.
No, thanks, Honorable Khan. Yeah, that.
Chair, the positions that the board influences in terms of our delegated authorities are executive positions. And all those positions, they're supposed to have gone through the vetting process. So when you actually ask somebody to act in a position that is parallel, you would expect that all the due processes have gone through. I'm just talking about in principle. And then the lower part, obviously, the CEO appoints acting incumbents in that process. We were, and we still accept that, we were sitting with a long list of vetting executives that hasn't gone through the vetting process. And we were basically told that the process is outside our control. And yes, we do accept that the SSA actually execute that process as long as all the members that are expected to be vetted have submitted their documents. But what has happened currently now with the CEO, that the acting CEO, he's an executive. He shouldn't have been gone through that process of being vetted or in the process of being vetted, basically. So you're not taking somebody at a lower level who hasn't been submitted to the vetting process to actually act at a higher position. But the lower level staff, then the executives actually appoint the executive. But it has been a concern to us that the vetting is an issue in this organization. But there are dependencies in the sense that there's certain areas of it that are outside of their control. And also we've been assured that the MIE integrity vetting process, that includes criminal checks, takes place before all the senior members go through, get appointed in terms of the appointments process. So yeah, no, but that's my answer, Chair. I don't know if there's another question.
No, it's fine. I think let's leave it, colleagues. We will never get sufficient answers. I think we must concede to that. You have a question for the chair. Let's hear the question for the chair.
Chair, my question
You
is...
want to interrogate me in front of our colleagues from the department?
No, Chair, I think now this is more a governance question for you. That if the board takes a decision and the chair or anyone else in that board refuses to implement that decision, does that not constitute insubordination? Thank you, Chair.
Yeah, thanks very much, colleagues. Colleagues, you will never get answers. It's clear, because you will get an answer, someone is going to contradict that answer. So it's not necessary, colleagues. I know, Honorable Montana, you are bending, you are itching, but I think we need to make this determination. Honorable Skwamba.
Can I just put one sentence to you, not to the team, Chair? Because it's proposal from my side. Chair, let me say in one sentence, because he's talking about governance. But I don't think that the issue the Chair is answering, it has to do actually with the very existence of the RAF in terms of the financial implications, the impact on the financial statements of this company. So this standard issue is not a small issue. It has to do with the very existence.
Yeah, thanks, Honorable. Yeah, thanks, Honorable Montana. Shukwamban.
Chair, mine is just a proposal, because I can see that bad things are happening here at RAF. There's genocide here at RAF. So
that's a big word.
Yeah, and then now I want to suggest, Chair, because I overheard your comment that you are actually pushing, or you are forced to chase these people so that we can have Mr. Litswalo alone so that we can ask him questions alone. But I want to propose that let's rather ask Mr. Litswalo questions in their presence so that they can lie while he's here.
No, colleagues, the chair has never been inefficient or ineffective in terms of guiding this.
No,
committee.
I'm not suggesting that.
I note your concern,
Yes.
but allow me to rule.
Thank you.
This is what's going to happen. We are not here to conduct a tribunal. We are here on fact-finding process. Therefore, we're going to have our own session with Mr. Litswalo. What has assisted is that he would have heard everything that was said here, that in case you are to ask him, he will still exercise his right, by the way, on matters that he feels that a sub judice he may not want to divulge here, just like they did. But I don't want to create a situation as if we are pitting the other against the other. That's not our responsibility. Our responsibility is to get information from Mr. Litswalo. I think I must clarify that to record. So we're going to afford that opportunity. I need to take this opportunity to thank the DM for having created an opportunity for these colleagues to come here and account. Had you not brought on debriefing, you have always indicated to me that there are challenges at RAF, but I don't think we have ever imagined that the extent of challenges is what we are dealing with now. I must be blank and honest. Where I'm seated, it may not be in my terrain, it may not be my province to make that type of a judgment. But there's a total governance collapse in RAF. At least at that level. I'm convinced. I don't want anyone to convince me again. There is, to the extent that even the DM acknowledges that they are what would use the phrase of factions at the governance level, it's a problem. And I really wonder to what extent that you even subscribe to the King's Corporate Report, the King's Code. I don't think you are even closer to that. But look, we appreciate the fact that you came. To the extent you could, you did answer. And to the extent you could contradict each other, you did. So that any other pronouncement we make from our side, it will not be a prejudice in whatever way. DM, like we've said from the beginning, we appreciate that, and that this is happening live when the people of South Africa are watching, so that they know exactly what they are dealing with, so that we are not seen to be sweeping other issues under the carpet and so forth. And the interventions that continuously you made assisted us also to open our thinking and our minds to see what is actually happening. We appreciate your honesty to say you have written a letter that cites us. We are going to request to see that letter. Formally, we are requesting formally that particular letter, that we need to see that letter where you are citing the PCOT in your writing relating to matters relating to governance. DM, I'm going to release you and the team. We appreciate it has been a long night. We'll remain for an hour with Mr. Litswalo to have our own interaction with him. And then from there, we'll then communicate with you of what we think should be from our side, the way forward. If you could say parting shot.
Chairperson, I want to thank the Portfolio Committee. I see that Honorable Montana is out, just on the very important point that he raised as a one-liner, to say to him that obviously there is consequence to the issues around the Concord, and hence the 21 days for an impact assessment to be done. And to reiterate what I said in this meeting, that we need to find a responsible way and manner in which we can deal with that particular matter, and hence the urgent need to engage with the ASB to indicate on this matter, which I'm meeting tomorrow. And then lastly, Chair, in is this. The challenges which we are currently experiencing at RAF obviously require a collective effort from all of us. And earlier on I said I met with the board and the executives yesterday. In that meeting I said, so that the committee can take comfort, we are here to point to where the challenges are, with a view to then take informed decisions about the future and direction of RAF. So it's a classic example of what the problem has happened now, that can you not characterize the fact that the chairperson of the board says she will not sign the papers as dissent, right? But what happened in this meeting when I said that? There was a direct contradiction from the executive. That's not what happened. Just before you hear, just now. Because I don't know what else it is. When the chairperson of a board dissents, and then you want to contradict me here. So it goes to the heart upon which RAF continues to present information. And I'm just wanting to issue a warning to the executives in your presence. Disabuse yourselves of this tendency. And Chair, as I've said, we have met yesterday, and we are going to apply our minds objectively in the interests of the RAF for the entire ecosystem, and come back to you with a concrete set of recommendations and the way forward. So I want to thank you very much, Chair, for this opportunity, because a part of me had assumed that after yesterday, we had all seen and taken time to reflect on the issues that were raised. I'm seated here convinced that that did not happen. There's a hardened attitude to continue on a path which I can only summarize around what Ms. Trunchbull says in the Matilda movie. I'm right, you wrong, I'm big, you small, and there's nothing you can do about it. That is the attitude at RAF. To the board and to the executives. Shape up or ship out. And we will come back to you, Chair, because RAF cannot continue on this direction. And so when the Honorable Malma just says it's embarrassing, he's correct. He's absolutely correct. And I apologize to the committee that you had to be subjected to this. This is not what a professional entity with a professional board and professional executives should be conducting themselves in a parliamentary engagement. And it's the last time, Chair, that such will happen. Thank you.
Thank you very much. That was your parting shot, DM. Just to concede that in my almost 10 years of involvement in legislative work, I've never faced this type of a circus. I've never faced this type of, which I could touch and smell a sense of dishonesty. I've never had that experience, but it is what it is. It's a trajectory that we have to traverse. It's a uncharted route that we'll have to charter. Thanks very much. Have a great night. We'll communicate you very soon. And there are certain information that we may need, including that letter, including the minutes relating to the Concord. No, I think acting DG thought I'm done. Acting DG, I'm not done. I apologize for the meeting. We're not done. Yeah.
I don't think you did it purposefully with intention to undermine the committee. But I think, colleagues, without wasting your time, go home, go and sleep. As part of sleeping, kindly reflect surely on your conduct today. Just take time in your own 2 minutes in your own corner. Ask yourself hard questions about what you are doing. There are more than thousands beneficiaries, by the way, DM, who are watching this with a sense that maybe they are going to be getting something that is helpful. But thanks very much. Have a great night. We are going to break just for 5 minutes so that you can allow them to go in. And if you can sit when you come, no, DM, you can go out. If you can come closer, so that you can come and sit here. The honorable members who have questions for you, there are those who don't have questions for you. Feel free to stand up and go, Matawat.